ठीक है, क्लास लाऊं क्या? बोलो, क्लास देखते हैं।
Right? My lord, may
May I make a mention?
My lord, may I be permitted to mention?
মৃন্ময়কে আমার কাছে পাঠাবে, আমি ওকে বোঝাবো, বুঝিয়ে দেবো একটু। চেম্বারে রাখো, হ্যাঁ, মৃন্ময়কে পাঠাবে, আমি বুঝিয়ে দেবো। One sec.
My lord, new chamber application, may I permit to mention new chamber application, my lord. Appellate side নেবে না? ওর যে জায়গা আছে,
এই অ্যাপিলেট সাইড তো আজকে নয়,
আজকে appellate side নেবে।
আজকে শুধু শুক্রবার অ্যাপিলেট সাইড, যদি না আমি অন্য কোনো স্পেশাল ইয়ে দিই, ইনস্ট্রাকশন দিই।
The mentioning will not be appellate side matter.
Sorry,
My lord, may I be permitted to mention a matter of Circuit Bench Jalpaiguri, my lord, a contempt application?
mention on Friday.
My lord,
Lordship,
My lord, it was
may I make a
returnable on
mention
7th,
for-
my lord, by your lordship.
For item number 23, 24 and 25, seeking a adjournment request.
When the matter will be called on.
my lord,
Lordship, I have a personal difficulty in my family. There is an issue. I have to rush over there. That's why I'm making a mention. Can it be posted on 30th of January? Because main matter is coming on that day. My learned friend is over on a VC.
Already,
My lord.
will be taken up as somebody next.
my lord, may I be permitted to new chamber application, my lord.
New chamber
Yes, my lord.
is returnable when?
Fourth was the fourth November was returnable date was. my lord.
Returnable 4th November.
Yes, my lord, that has been passed.
ঠিক আছে, দিয়ে দিন,
The matter is
কালকে দিয়ে দিও,
execution.
give
matter.
notice.
Yes,
Yes, madam.
notice has already been given. Execution matter is, it was fixed for 6th of November. It was not said, so I want to mention this today.
For what?
It was for hearing of execution. It was not listed, and I am mentioning this.
For application, final disposal. Yours is final disposal or new?
New chamber, my lord.
New chamber.
Affidavit, your
My name is execution for it.
affidavit,
Already everything has been completed.
Final,
Huh?
final.
Or
Or
final,
final, my lord.
final.
final disposal দিয়ে দাও। এটা
May I have,
next মঙ্গলবার final disposal.
Next.
may I have my lord's kind leave,
Yes,
may I to mention item number 32 of my lord's list. My lord, the interim order is expiring today. My lord, only my lord, for that reason I mentioned.
I cannot reach that mention at the time of rising.
my lord, may
Very
I,
well, very well.
my lord, this is a commercial suit that is pending since 2021, my lord. The matter was made
Hearing of
returnable.
suit,
Yes, my lord.
not now, next.
My lord, we were already in the middle of the hearing, my
That's
lord.
precisely the reason.
My lord,
Next.
another matter, my lord, an execution petition, my lord. If the matter was returnable on 4th of November, my lord. If the matter could be listed, my
It's
lord.
final disposal or new?
My lord, it's a new matter. The arrest warrant has been issued, but the police authorities have not been able to arrest the
So
judgment
ये
matter.
affidavit direction made.
Yes, my lord.
So it is not a new matter.
No,
It is
my
a
lord.
Then you are saying new. Final disposal. Chamber final disposal next Thursday.
Grateful, my lord.
Next Thursday week. ওটা আগেরটা টিউসডে উইক। তারিখ দাও বাবা। শোনো, তারিখে যেন ঠিক মতো পড়ে, যেন আমার শুনতে না হয় আমি এই বলেছি ওই এসছে, ঠিক আছে? এবং ঠিকভাবে সেই দিন যেন লিস্টে আসে।
My lord, the commercial suit has been pending for
Next.
long, my lord.
My lord, may I be item number 34, your lordship says, lordship, the interim order is expiring on the 14th.
If I don't reach, then mention at the time of rising.
My lord, may I be permitted to mention, my lord, a suit which has been renumbered as a commercial suit pursuant to Justice Mujumdar's direction on the 15th of September 2025. My lord, the suit has been renumbered as CS-Com 181.
Very well.
My lord,
Hearing of suit.
no, my lord, it has to be included for
My
your
lord,
lord.
I'm leading Ms. Bhattacharya. My lord, the directions under section 15(1) has to be given by your lordship. It was marked as a non-commercial suit initially filed in 2013. Justice Mujumdar felt it's a commercial suit, so it needs to be transferred to the commercial division. Now, in terms thereof, my lord, it was placed before the registry for renumbering. But my lord, the 15(1) directions have to be issued by your lordship. I'm not seeking hearing of the suit, my lord. I know your lordship has indicated your lordship's mind. Only the directions may be passed so that we can comply with it in the meantime.
Why the court? There is no function of court.
Milord, that direction for filing of statement of truth and all that, the registry will not accept unless your lordship's direct. That is the difficulty we are facing.
What direction I will make, sir?
Milord, your lordship will only have to direct that the suit, the cost papers be made compliant of the Commercial Courts Act, because the statement of truth and the affidavit of documents in terms of 11.1 Rule 6 has to be complied with in terms of the statute. The registry will not accept these affidavits.
My question is, Mr. Ghosh, if one learned judge, if one learned judge directs it to appear as commercial suit, then it is the responsibility incumbent upon the department to convert.
I know, my lord, the difficulty is that the department doesn't act in terms of this. They
You-
say you have to file with leave of court.
You just write a letter to the department that pursuant to the annex the order of Justice Mojumdar.
Yes, my lord.
Say that please convert it, then let them refuse it. Then we will.
Very well. We'll do that. Grateful, my lord.
সবকিছু কি কোর্টে হবে নাকি?
No, it's not supposed to be. The department has to take steps.
Absolutely. একটুখানি ঘুরিয়ে দাও
Grateful, my lord.
তোমার দিকে। বাস। Thank you.
Praying for my lords, kindly to mention a matter on the personal request of the receiver appointed in the matter, my lord. The receiver is to carry out some directions tomorrow, that is on 11, but he has some personal difficulty, so he's requested if the matter can be listed as to be mentioned tomorrow, so that he can come and make
He has to carry out the direction to
my
be
lord,
is mentioning.
he has some personal difficulty, my lord.
To be mentioned tomorrow.
Grateful, my lord.
Next, please document.
Item number 1, presentation of claim. For the plaintiff, may I pray for a very short Passover, my lord?
Sorry. Next. It will appear sometime after, not now. Ashun. Presentation of plain সেখানে pass over. Ashun. Your name, sir?
May I then present the plain, my lord?
Yes, please.
The plain, my lord, seeking a my lord, that the deed of declaration was handed over to the bank.
Take the microphone.
The deed of declaration that
What is the leave you are seeking for?
leave under clause 12 latest patent, as well as, my lord, leave under section 12A of the Commercial Courts Act.
Satisfy me on 12A. Where are the pleadings?
I'll be very candid, my lord, I'm not ready, my lord.
Ashun. Mr.
Shovik Kundu.
Shovik
Kundu.
Shovik Kundu, learned advocate, appearing for the plaintiff, prays for an adjournment of the proceeding for presentation of plaint. Poster. The matter shall appear under the heading presentation of plaint on. Aji koto? Huh? November 19, 2025.
It could be 17th, my lord. That's only I if I could. 17th, my lord, if lordship kindly keeps
No.
it. 2 days, my lord.
17th, ঠিক আছে।
Grateful.
17th.
Item number 2.
Your Lordship, I appear for the
Yes, why to be mentioned?
Your Lordship, I appear for the plaintiff in this matter. It's an
Take the microphone, take the
I appear for the plaintiff. This is an undefended suit, Your Lordship. It is at the stage of final conclusion of the arguments. Your Lordship, it was substantially heard before Honorable Justice Krishna Rao.
So I'm releasing the matter.
Yes,
Right. MS, on the prayer of MS.
Shreya Goenka.
Shreya
Goenka. Shreya Goenka.
Shreya Goenka, learned advocate, appearing for the plaintiff, which is undefended suit, comma, which is an undefended suit, comma, since the matter has been lying under the argument stage after being substantially heard by the coordinate bench, comma, on the prayer, comma, the matter stands released from my list. Full stop. Paragraph. The records shall be placed before the Secretariat to the Honorable the Chief Justice. Record shall be placed forthwith before the Secretariat to the Honorable the Chief Justice for taking steps for taking necessary steps. Chalo. None appears for the undefended. Chalo.
Great.
Next. Why? To be mentioned.
Correct.
Take the microphone.
I have an application for disclosure of additional documents. And my lord, this matter had come before because the mandate of the learned commissioner who was taking evidence has expired on 4th November. My
So
lord,
your application before the commissioner.
no, I could not move it before the commissioner. I have to file it in court. I have filed it in court. It is appearing before your lordship. Lordship had indicated that lordship would hear out that said application.
No, but if I extend the time,
My lord, will ultimately have to extend the time with respect to
so if I extend the time, then you.
Well, this application has to be
Then
heard
also
in-
you have to move before the court.
My lord,
Additional document.
additional documents.
Very well, it will appear in the new under the heading new motion Monday. Ashun.
Great.
MS Hashnuhana Chakraborty, learned advocate, appears for the plaintiff.
Defendant.
Defendant.
Yes.
Mr.
Shourojit Dashgupta.
Shourojit Dashgupta, learned counsel, appears for the plaintiff. Paragraph. An application has been filed by the defendant for filing additional documents. Full stop. The examination of witness is in progress before the learned commissioner.
Plaintiff's witness is complete.
Learned commissioner, but during such progress, the time frame stands expired. Paragraph. Accordingly, the matter shall appear under the heading new motion on 17th.
Affidavits are complete. I should indicate affidavits are complete.
Oh, in that matter, affidavits are complete.
My lord can hear out. My lord, it's a very small matter.
Very short point.
Let it
No,
come
it's all
to the
right,
motion.
all right. But then it will appear as adjourn motion on Monday. What affidavit you have used? They have used.
But
Well, like saying there is
Their
no
application-
fault which has been made out, and secondly, it should have been in chambers. These are the two defense. If I am
in the chambers, I'm not pressing that point. But insofar as the defendant's entitlement to produce additional document at the time of trial in a commercial suit, the defendant has to satisfy that at the time of filing the written statement, the documents were not in his possession power.
Diligence was there.
Yes. And the commercial
What
books
the
are,
documents were not available.
yes,
Akin to Order 41, Rule 27.
absolutely.
this is
ma'am,
reasonable
absolutely.
cause, not good cause. So possibly.
No, akin to. I'm saying akin to. On a come and adjourn motion, we will see.
Great.
Next.
New motion, item number 4. The Frisian Group Company Inquiry.
I appear on behalf of the petition.
Pigeon roof, I appear. I released previous matters. Pigeon roof.
Region roof, it is not that matter, ma'am.
No, maybe. For some time I shall not take up this. I appear once. Ashu. The matter stands released from my list on my personal ground. Full stop. The paragraph. The records are directed to be sent before the Secretariat to the Honorable the Chief Justice for necessary assignment. সবার নামগুলো সাহেবদের দিয়ে দেবেন।
I may interrupt. My lord was about to extend the mandate of the commissioner, which possibly was not ultimately dictated.
I have not extended. I will take up on the next day. Because unless your additional evidence goes, no
point
further
extending,
fruitful.
no point
Right.
extending.
That's why I will consciously.
Great.
Item number 5.
I am for the defendant.
My lord, I am for the plaintiff.
Parties have settled the suit.
My
They
lord, I have-
dispute amongst themselves terms of settlement.
Terms
My lord,
signed by all the parties.
Yes, there are two parties.
there are
the
two
plaintiff and
parties only,
defendant.
my lord. This is my
How many defendants?
One.
only one defendant, my lord.
দেখি
And under the
কাগজ
terms,
and have
a sum was about to be made.
ও নো পেপার লেখা আছে তাহলে করো না কাগজটা আসুক it will remain as it is
My lord.
just passed over for the day
We'll come back.
If paper comes,
We'll come back.
see that the paper comes so that I can take up tomorrow.
Great. Deeply.
New chamber application. Item number 6.
Lordship, I appear for the plaintiff in this matter and for the defendant number 2 in this matter, Your Lordship. This is my application
You have for?
of defendant number 2. My
Yes, sir.
application for filing the written statement beyond the period of 30 days. Your Lordship, today is the 118th day.
119
day. Within 120 days, I am supposed to file my written statement.
119 today.
Yes, Your Lordship.
I have delivered a judgment.
Yes, Your Lordship. The written statement has already been affirmed on Friday itself. If this application is allowed, I'll be permitted to file the written statement in the department.
এই একটা কাজ করবে আমার ওই জাজমেন্টটা বের করাও তো give me a copy my judgment.
I do not have it with me right now.
You don't have, you have not seen it.
No, Your Lordship.
Yesterday somebody now when the matter was mentioned last day I indicated that I have delivered a judgment, look at it. এক কাজ করো তো একটা পাঞ্চ করে ফাইল করো ফাইল আছে তো এখানে
This is
Central
Jaykumar.
Bank.
Yes, I have. I'll just tell.
Who mentioned the matter? You mentioned. Somebody on your behalf mentioned.
Lordship.
I categorically indicated, look at my judgment delivered 2 days back. He did not find the time, bothered to look at. All right. Show me the reasons. Where is your
Lordship, what has happened
supporting
in this
affidavit?
case? Lordship, affidavit in support is along with the master summons. Lordship, the company has actually, defendant number 2 is a company which has already been admitted under CIRP. It has gone into insolvency. And Your Lordship, the resolution.
Difficulty in preparing the written statement. Then who shall affirm? Then it would have been.
Lordship. The resolution professional has been appointed, Your Lordship. He is in charge of that.
Yes, show me what are the paragraphs.
Lordship, may kindly see paragraph number 6 of my affidavit in support. I say that the plaintiff had filed several documents which needed examination subsequent to the completion of corporate insolvency resolution
Take the microphone.
of the corporate debtor. That is defendant number 2 herein. The successful resolution applicant,
One second.
new management.
1 second. শোনো একটা না ওই বই আছে তো আমাদের এখানে দেখে রাখো ওই ইনসলভেন্সি প্রসিডিং এ আইবিসি ইনসলভেন্সি কোড ইনসলভেন্সি এন্ড ব্যাংক্রাপসি কোড লেটেস্ট বইটা দেখো নিশ্চয়ই থাকবে দেখে রাখো
Lordship requires a copy. I have a copy of the code.
Sorry.
The successful resolution applicant, new management, has taken over through the said process of
ধুলো
CIR.
ঝেড়ে পরিষ্কার করে দাও বলো বই ওদের বলো ধুলো ঝেড়ে পরিষ্কার করে দেবে You are appealing for defendant number 2.
Yes, Your Lordship.
Balaji.
Yes.
Balaji paper.
Lordship, this is Balaji Paper and Newsprint Private Limited.
Where is your written statement in the master summons? In the affidavit, supporting affidavit? Where have you annexed?
Lordship, the written statement has been affirmed separately on Friday itself.
Have you served it?
Yes, Your Lordship. Service has been completed and
Show me that you have served the written statement.
the affidavit of service.
ঠিক আছে এখন থাক রাখো ওখানে রাখো
Online filing receipt is online filing করার সময় তো আপনাকে সার্ভিস করে ফাইলিং করতে হবে।
আর ওই জাজমেন্টের ফাইলটা আমায় দাও পাঁচ করে
Subject to correction, we have not received the written statement. That's the only. We have not received it. Yeah, plaintiff.
The service হয়নি? No, not this.
With my lord's leave, my lord.
এটা কেন ফাইল পাঞ্চ করা ফাইল নেই?
অ্যাপ্লিকেশন অ্যালাউ হয়নি তো এখন।
না
দাও দাও, এই যে ফাইলটা এখানে পাঞ্চ করা, যেটা ঢুকিয়ে দেওয়ার ফাইল,
কোনটা?
স্টেটমেন্ট
ওই
ক্যানেল ফাইল কেন?
affidavit service আছে?
যেটা আমাদের ফ্ল্যাট ফাইল
এটা মাস্টার সামনে
পাঞ্চ করে এখানে রেখে দেবে। আনাও
আমাকে সার্ভিস করেছে।
আনাও আনাও,
স্টেটমেন্ট আপনি অনলাইন ফাইল করতে
কিংবা একটা আর্চ ফাইল আনাও, যত জাজমেন্ট হবে কমার্শিয়াল কোর্টে সব একটা করে রেখে দেবো। আনাও আর্চ ফাইল আনাও, রিকুইজিশন করো, বলো এক্ষুনি চাই আর্চ ফাইল, সেইখানে দেবে। আমি এখন রাখছি, বাট সেইখানে দেবে।
My lord, may I attempt? The written statement that I had taken out was after a period of 30 days. So, my lord, I had to take out an application for the purposes of acceptance of the written statement. I had filed the written statement in the extended period of 120 days, and my application is also on record for the purposes of acceptance of the written statement. This, however, my lord, in my written statement also it is clear, is without prejudice to this application that I am moving. My lord, so the written statement officially is yet to be taken on record. With respect to the master summons in the other GA that I have taken out, they have received that application.
But why you have not served the written statement on it?
Possibly not, because it has not been filed with the court, because yet to be accepted by this court.
An advance copy?
Advance copy filed. No, my lord, possibly the advance copy has not been served. We were under the impression that once it gets accepted by this court, my lord, we would then and there serve, my lord.
What is the pleading? Show me.
Written statement আছে? Yeah, written statement আছে.
Have you brought the list of dates? When the writ of summons was served, when you have received?
J5.
Tell me, give me a list of dates.
If my lord kindly takes GA4, my lord.
Yes. Yes, GA4.
In GA4, my lord.
Show me what are the dates pleaded.
Yes. My lord kindly comes to paragraph 3 at page 3.
Yes.
My lord, may I please? I say that the present petition is being filed by the defendant number 2 for acceptance of the written statement that has been filed after 30 days. However, within 120 days from the receipt of the writ of summons, it is submitted that the written statement has been affirmed on 7th November 2025, that is 86 days beyond the 30 days from the receipt of the writ of summons on July 14th, 2025.
1 second.
I'm sorry.
Written statement has been affirmed on 7 November.
November
That is
7th.
80 days beyond 30 days from the date of receipt of summons.
86 days, my lord.
Correct. When you have received summons?
On the 14th of July 2025.
So the 30 days expired on 13th of August.
August. 13th of November onwards, my lord, I would have been out of time. I affirmed my written statement on the 7th of November. I don't know. Thank you very much.
So the CLB proceeding was initiated much prior.
Much prior.
When there was no suit, no writ of summons.
Okay. As on date, my lord, we have been taken over by another company. The defendant has been taken. And may I just show the intimations that were made to the public with respect to the insolvency proceedings?
Show me the plaint. And arch file আনিয়ে নাও, তাহলে অনেক জাজমেন্ট ঢুকে যাবে সব কটা। Show me the plaint.
May I hand over my copy?
Plaint এসছে?
Kindly excuse me, my lord, if there are a few markings.
Doesn't matter. For goods sold and delivered. How you were pleaded?
Lord, will
What was your role according to the plaintiff?
I was
Waste paper, supply of waste paper to the defendant number one. My lord, supply of waste paper to the defendant number one by the plaintiff on the basis of invoices. The waste paper was duly supplied, but the defendant number one, being a proprietress of a sole proprietorship concern, asked us to deliver it to the factory premises of defendant number two. Lord, so the defendant number two, as far as D2 is concerned, Lord, has been impleaded as a party because the supply on the basis of the order
Goods were received within the premises of defendant number two.
That is the plaint.
Plaint case to plaint case.
Defendant number one has filed its written statement.
Lordship, I haven't filed my. I'm for defendant number one, Your Lordship. Haven't filed my written statement yet. I'm well within 30 days. 30 days ends on the 27th of November, Your Lordship. I'll file it within that, Your Lordship.
Achha, you are within 30 days.
Lordship.
During the insolvency proceeding or the insolvency resolution proceedings, may I just indicate to my lord the announcements that I am required to under law to make for the purposes of inviting any claims. If any individual has any claims against me, my lord will kindly take page 29 once, my lord, of my application. In my understanding, my lord, in accordance with law, I have taken all steps possible to intimate to any creditor that I may have that to
You
take
are under insolvency proceeding.
Yes.
So for your reconstruction, financial reconstruction, matter is pending before NCLT.
Concluded.
Concluded.
Concluded. I have been taken over, my lord. I have also pleaded.
You have come out of the insolvency proceeding.
Yes.
Went
I
into
am-
CIRP, my lord. Now under the IBC, my lord, as your lordship is aware, first the moratorium, then moratorium. If there is a company which comes to take it over as a going concern, then the company is sold as a going concern. What we understand from their affidavit that they have been taken over
as a going concern.
So not
No,
in
but
insolvency.
defendant number two just received the material according to the plaintiff.
Yes.
Right. So he at best can file his written statement to that extent. Whatever. That is not the lookout of the court.
It is my case in the application that I am attempting to move before my lord, that my slate has been wiped clean. That my slate has been wiped clean. If they had...
Why have you waited so long?
I'm sorry, my lord.
Why you have waited till 119th day?
Lord, because after the I was purchased as a going concern and the new Pinax paper mills.
Where is your pleading that after you are purchased as going concern? Show me.
My lord will kindly take my application. Excellent. Paragraph 9, my lord, at page 5, my lord.
Read.
During the course of the corporate insolvency process of the corporate...
Paragraph 9. I
Correct.
say that filing the written statement is a valuable statutory right.
Not for the acceptance of the written statement. The application that I filed for striking off my name from the record, my lord. GA1, my lord.
That is not here.
That is not. I am sorry.
You show me from your
I'm sorry.
explanation.
My lord will kindly take paragraph 6 at page 4.
Yes.
My lord, may I place? I say that plaintiff had several documents which needed examination, and subsequent to the completion of the corporate insolvency resolution process of the corporate debtor, being the defendant number 2 herein, the successful resolution applicant or the new management has taken over the said process of CIRP as per the provisions of the Insolvency and Bankruptcy Code 2016, and it took time for the successful resolution applicant, being the new management, to understand and seek clarification of the entire facts and circumstances of the plaint and to ascertain the veracity of the documents and records relating to the pre-CIRP process. However, in the last week of October 2025, the entire picture became clear to the defendant number 2, and the defendant number 2 immediately looked for legal help. I say that the delay in filing, delay, if any, in filing of the written statement is wholly unintentional, inadvertent, and in no manner aimed at delaying or digressing from the process of this honorable court. Any delay is solely on account of the fact that the defendant number 2 wished to ascertain the veracity of the plaintiff's claim thoroughly before averring any stance before this honorable court. Now, this is primarily because the plaintiff's claim were not before the Honorable National Company Law Tribunal. Had that been there before the National Company Law Tribunal, it would have been a different scenario.
My lord, I per se do not object to this application, my lord. They are well within 120 days, my lord.
Because not only that, as plaintiff, your pleading and your case is very restricted to the extent that he is merely has received the material.
Yes.
You have no monetary claim against them.
I don't.
It's really the plaintiff number 1
Yes.
who has to suffer, if at all, a money decree.
Yes. Absolutely, my lord, and within 120 days, my lord, and your lordship's judgment, my lord, also about the valuable right, my lord, that squarely applies to them also. They are within 120. My lord, only 2 things, my lord, I would want to point out. My lord, if your lordship takes paragraph 6, my lord, they have pleaded what has happened before the company.
NCLT.
My lord, no documents envisaging what has actually happened, my lord. I am also taking it as an affidavit that has been affirmed that this is all true and correct, my lord.
Show me the last order of NCLT.
Nothing has been, my lord, that's my only...
Then may I beseech my lord to kindly take my application being GA1, my lord. My orders are annexed there.
এই GA1 কি এখানে আছে? নেই।
GA1 complete. I am sorry, my lord. GA3.
GA3 আছে? নেই।
May I have a soft copy?
I have a copy. I can, if
you look at it.
Yes, my lord.
I have an
Look
extra.
at the order. Look at the order. Show me the order. The final order.
Yes.
NCLT.
My lord will kindly take page 30.
Yes.
Take korbe.
Yes, my lord. This is the order. They have
ফাইল আসেনি এখনো?
My lord, this is an order.
ফাইল পাঠিয়েছো? আমার জাজমেন্টটা দাও। ও আমার কাছেই আছে। ঠিক আছে।
January 12, 2024.
Yes.
From paragraph 6 onwards, the particulars of the corporate debtor are set out. However, if I may take my lord to
my lord, page 62 of the application, my lord, this has been, whatever has been stated is really page 62, paragraph 40.
This is annexed like this.
It's annexed.
উল্টো পাতাগুলো উল্টো আছে। Page 60.
I am not giving credit.
Page 62, internal page 32 of the order, at page 44. I think
paragraph
44.
Internal page 32 of 34.
This I think then.
All right.
Lord, may I pray for some costs? That is something.
That's incumbent.
Yes, my lord. That is exactly why, my lord.
That is the language
of
CPC. That's the language of CPC.
No, that's order 8 rule 1.
Order 8 rule 1 states.
Yes, my lord. That.
Ashur. This is an application. Please listen to me.
Yes.
কি হয়েছে গো? এই মিনময়কে আমাকে একবার পাঠাবে। হ্যাঁ, ওই যে জাজমেন্টটা ছেপেছে আর একটা ইনসারশন হবে, মিস করে গেছে, ওটা আমি দেখিয়ে দেবো কোনখানে হবে, তাহলেও বুঝতে পারবে। যখন আসবে দুপুরবেলা না, এই শোনো না, 12:20 ফুড়িতে আমি নামবো। একবার ওকে বলে রাখো, একবার এসে আমার সঙ্গে চেম্বারে দেখা করতে, জাস্ট যে জায়গাটা হবে আমি দেখিয়ে দেবো। কি বললাম? This is an application in no, এইভাবে লিখুন। The master summon has been taken out. Inter alia praying for extension of time to file written statement in a commercial suit beyond 30 days, but within 120 days. 30 days, 120 days, কথাটা তো bold. The averments paragraph, the averments
Who defendants?
চাই তোমার
Issue.
made in paragraph three to the affidavit in support of master summons shows that there is a delay of about 86 days beyond 30 days. Full stop. The writ of summons was received by the applicant defendant number 2 on July 14, 2025. Date bold করো। আচ্ছা, কিভাবে শুরু করেছি? দি মাস্টার সামন্স পড়ো। না না, তার আগে মাস্টার সামন্স হ্যাজ বিন টেকেন আউট পড়ো। Must have been taken out by the defendant number 2. বাস, আর কিছু লিখতে হবে নিচে এসো। কি বলেছে? ফুল স্টপের পর the writ of summons of applicant slash defendant number 2 2025 bold. The application, the master summons has been taken out on
Master summon has been taken out on 7th day of November 2025.
November 7, 2025, which is
16th day. 116th day.
116th day. 116th day টা করে post. The principal plea, principal grounds pleaded in the supporting affidavit in support of the reliefs claimed in the master summons are quoted below. Set out para 4-2. Para 8. Quote 1. ঠিক আছে, লিখে রাখো। ঠিক আছে বাবা, প্যারা কত বললাম? Quote 1. Post. Para. Mr. What's your name, sir?
Rishabh Karnani.
Rishabh Tandon.
Karnani.
Karnani. Mr. Rishabh Karnani, learned counsel appearing for the plaintiff, refers to a copy of the plaint and submits that the plaintiff has filed the suit for recovery of unpaid consideration on account of goods sold and delivered to the plaintiff number, to the defendant number 1. Full stop. The defendant number 1 has failed and neglected to pay the price of the goods to the plaintiff. Full stop. At the request of the plaintiff, defendant number 1, goods were supplied to defendant number 2, who has accepted the goods on behalf of defendant number 1. First paragraph. Mr.
Bandopadhyay, Pourush Bandopadhyay.
Pourush Bandopadhyay, learned advocate appearing for defendant number 2, submits that the defendant number 2 initially had undergone a resolution proceeding before the jurisdictional NCLT, and finally the proceeding has concluded on
January 12, 2024.
January 12, 2024. When the present management has taken over the defendant number 1, right?
Yes.
In view of
defendant number 2, Milord.
Sorry, defendant number 2, in view of the resolution scheme. Full stop. Paragraph. Learned counsel for the defendant number 2 then submits that after gathering all the records, it took a substantial time for defendant number 2 to prepare the written statement. Full stop. The written statement has already been affirmed on
November 7, 2020.
November 7, 2025, on the 116th day itself. After considering the rival contentions of the parties and on perusal of the materials on record, it appears to this court that so long 20th day expires from the date of service of writ of summons, the defendant has a right to claim an extension, of course, if the grounds are accepted to the court under the amended provisions of Order Roman 8, Rule 1 of the Code of Civil Procedure. Paragraph. Paragraph. Furthermore, when the legislature thought it fit to introduce a provision for awarding cost as the court deems fit, under the said amended provision of CPC, this court is of the firm view that upon payment of a penalty by the defaulting party, a curative provision has been laid down by the legislature so that the defaulting party shall not be debarred from taking its defense to the claim made by the suitor against it in an action subject to restriction of 120 days as provided thereunder. and subject to the satisfaction of the court. Post. Paragraph. Right to file written statement is also a statutory right which is in conformity with the elementary principle of natural justice. Full stop. If the defendant is denied of this right of filing written statement, comma, if it is otherwise permitted to be filed by extending the time to be extended by the court within the meaning of the four corners of the relevant statute, comma, then such valuable right to defend the proceeding by the defendant would not be defeated. Full stop. Full stop. For procedural lapses, comma, substantive justice should not suffer by taking away a substantive right of a party. Full stop. Paragraph. After considering the averments made in the writ petition, in the supporting affidavit, and upon hearing the parties on their respective contentions, comma, this court finds that sufficient cause has been made out and the defendant number 2 should not be shut out from filing the written statement since they are within 120 days mandate. They are within the mandate of 120 days provided under Order 8, Rule 1 of CPC. Paragraph. The application. Now, the time to file written statement stands extended till today, subject by the defendant number 2 before the department concerned, subject to payment of cost of rupees 50,000 to be paid by the defendant number 2 in favor of the legal aid, state legal aid services authority, comma, West Bengal, within 3 working days from date. Full stop. The written statement shall be filed and accepted by the department concerned today. Full stop. The defendant number 2 shall produce its money receipt showing payment of cost to the learned advocate on record for the plaintiff immediately upon payment, and in the event the cost is not paid, the written statement shall be returned and no cognizance shall be taken thereupon. First paragraph. With the above observations and directions.
Not just a direction for serving the written statements.
With the paragraph, the petitioner, you serve here and now.
In the course of the day.
The defendant number 2 shall serve a copy of the written statement upon the learned advocate on record for the plaintiff by today. By tomorrow. By tomorrow. Paragraph. With the above observations and directions, this application GA com bold হবে ঠিক আছে বাবা তোমার নাম কি রিন্টু যাই হোক আমি নাম ফাম ভুলে যাই কিছু মনে করো না কি বললাম with the above observations and directions bold this application bold GA bracket com 4 of 2025 4
Yes, my lord.
2025 stands allowed, comma, without, stands allowed.
Actually, may I just pray for reduction in the quantum of the cost?
Huh?
May I just pray for reduction in the quantum of the cost?
1 lakh, 1 lakh.
Reduction.
Next. হ্যাঁ না এটা জাজমেন্ট ফর্মে করো, জাজমেন্ট ফর্মে করো J2 আর আপলোড হবে জাজমেন্ট হিসেবে, জাজমেন্ট হিসেবে J2 ফর্মে করো।
My execution application, Your Lordship. On the last occasion, my lord, the Honorable Single Judge had directed to serve. My lord, we have already
Decree of 2 years back.
Decree, my lord, of my lord, I'll tell Your Lordship.
দেখি না কাগজটা দাও না।
My lord, the decree was passed on 10th April 2024, my lord.
2024.
Yes, my lord.
Show me the tabular statement.
My lord, will kindly take the execution application first.
Yes, I have taken it. GACOM 2.
GACOM. No, my lord, the GACOM 2 is an application filed by us, Your Lordship, for filing of affidavit of assets and the personal guarantee, personal presence of the
Which
person.
you are pressing today?
My lord, I'm pressing this GACOM 2, Your Lordship, because Your
GACOM
Lordship,
2.
yes, my lord.
Show me the tabular statement.
I will kindly take the execution application once.
Master summons.
Master summons. Master summons page 2, Your Lordship.
Where is the tabular statement?
My lord, it's annexed with the execution application, my lord. The main execution application. It's an application.
Main execution.
Yes, my
Show me. Now master summons now. Main execution.
Execution application ta dao na ekটু. Lord, may I give my copy of the execution application, Your Lordship?
No, I have got it.
My lord, the master summons is annexed with the execution application, my lord.
ECCOM 405.
Yes, my lord. Yes.
Master summons now.
My lord, Lord, may I
ও
give
বললে
my
তো আমি মানবো না।
execution application, my lord?
ও বললে তো আমি মানবো না।
Tabular statement.
Where is your tabular statement in the original? দেখি দাও, অরিজিনালটা দাও, খুঁজে বের করো। অরিজিনাল মাস্টার সামান্সটা কোথায়? দেখো GACOM এর মাস্টার সামান্সটা বের করো বাবা। 400 কত? 405।
My lord, the tabular statement is here, my lord.
শুন দাও, ছেড়ে দাও, দাও এটা ফেরত দাও। মাস্টার সামান্স। Yes.
Lord, will
What
kind-
is the suit for?
The suit was for recovery of recovery of money, Your Lordship.
On account of?
On account of, my lord, they had supplied us defective bamboos.
Goods sold and delivered.
And delivered, my
All
lord.
right.
Now, we had obtained a decree on 10th April 2024.
You are the purchaser.
I am the plaintiff, purchaser.
Purchaser.
Yes, ma'am.
So it's by way of how you have realized the decree. They have sold the goods.
No, my lord. My lord, will then kindly take my execution application.
How you are related to the plaintiff? Que the plaintiff? How you are related?
But I am the plaintiff, Your Lordship.
You are the plaintiff.
I am the plaintiff.
I'm so sorry. You are the plaintiff. You supplied material.
No, my lord. I had purchased from the defendant.
Right.
They had supplied us defective goods.
Correct.
And my lord, pursuant to
Okay,
that,
so you have paid the purchase price.
yes, my
But
lord.
after
And
you
there
found
was-
the goods being defective, you
there
paid
were-
the money back.
there were 3 bank guarantees. We claimed the money back.
Forget it.
We claim the money back, my lord.
So you wanted the money back.
Yes, my
That's right. Wait.
I will kindly take the decree once then.
Yes.
Well, if
Now you
lordship
show me.
pleases, I have prepared a detailed list of this. May I hand it over to your lordship?
I don't mind, sir. But what do you want today? Tell me.
Well, we had filed two applications, GA2 and GA3. Well, GA2,
So I am taking up which one?
well, both are there in the board today.
Sir, which one? You will
Well,
move.
I'll press GA2 today.
Today, which matter is supposed to be taken up? Previous
GA2,
order?
well, it will kindly
Okay,
take the
order sheet
previous
karo.
order, the last day's order.
Last day's order? Show me.
Well, 9th September 2025, my lord.
What does it say?
Well, there was a direction upon the judgment debtor to file affidavit of assets, and my lord will kindly take the last three paragraphs. Paragraph number 4, 5, and 6, and 7, my lord. Now, my lord, the receiver has already taken possession of the property.
Which property?
The property, the
judgment
debtor's property.
Acha.
The receiver has taken possession, but that is GA2. That is GA3, my lord, the application for receiver. That has been considered. And my lord, today we'll press the application for filing affidavit of assets that had been considered by the honorable judge on the last occasion.
Direction was made.
Direction was made. No affidavit of assets has been filed.
All right. Which is why State Bank was party?
Well, State Bank was holding the bank guarantees.
Give me a copy of the plaint.
Right, it's partly marked, your lordship.
Doesn't matter. Just give it to me. Which defendant is supposed to disclose its assets?
Well, the defendant number 2 is supposed to disclose, my lord.
State of Madhya Pradesh.
State of Madhya Pradesh.
It is not done.
No, my lord.
Receiver appointed by this court has gone to Madhya Pradesh.
Yes, my lord.
Taken possession.
Filed a review application.
My lord, they had filed two applications. They had filed a review application that was dismissed, and my lord, they had filed an appeal which was also dismissed. The review application was withdrawn.
Appeal from which order?
My lord, the appeal from the order dated.
Come on, tell me the content of the order.
Appeal from the order from which the receiver was appointed.
Correct.
Now, in the garb of that, they had challenged the decree.
Forget it. So the appeal has been dismissed.
The appeal has been dismissed. Now,
Right.
subsequently, they had filed a review application of the original decree.
That is also dismissed.
That was withdrawn.
Whatever.
Withdrawn.
So
Now,
today the order for disclosing affidavit asset stands.
Stands, my lord.
Right?
My lord, I'm being led by Mr. Shengut.
Not required. You are doing well. Do it. Take your seat. Very well. So the respondent is not appearing today. All right.
My lord, we'll press for a personal appearance of the respondent.
State of his Madhya Pradesh personally asbe. Listen to the order I am passing. Then if you want any further submissions to make, I will hear you. Ashu. Acha, first tell me which one is this application? In which?
This is GA2, application for affidavit of assets and personal appearance.
Ashu. In re GA2, GA-com 2. শোনো যেটা বলছি এই নম্বর যখন দেবে মাথার উপর যেমন অর্ডার শিটে আছে সেরকম ছাপবে আমি কোনো চেঞ্জ করব না কারণ চেঞ্জ করলেই পুরো সিস্টেমটা ঘেঁটে যাবে
7-8 দুটোই আছে।
আচ্ছা 7-8 দুটোতেই একটা অর্ডার করো, রি ইন রে বলে GA2 তে অর্ডারটা হবে, যেটা অ্যাফিডেভিট অ্যাসেট ডিসক্লোজ করার ডিরেকশন। চলো ইন রে GA2 দুটো একসঙ্গে কম্বাইন করে দাও, ইন রে GA2 লেখো। GA2 এর প্রেয়ারটা দেখাও তো।
My lord, can you take the master summons page 2 and 3?
Wait. আসো। Instant interlocutory application has arisen from the main execution proceeding being bold EC Com 405 of 2025. আজ ফাইল এনেছো তো? হ্যাঁ, ফুল স্টপ। কি লিখতে হবে ছাপতে হবে আমি পরে বলে দেবো, ফুল স্টপ। Paragraph. So the instant application IAGA Com 2 of 2025, the decree holder plaintiff decree holder has prayed for disclosure of particular assets of the judgment debtor number 2 by way of affidavit. By way of affidavit, and failing which, and in case and in the event of disobedience, the personal appearance of the concerned secretary of the state of Madhya Pradesh. Paragraph. The decree was of
My lord, 10th April 2024.
April 10, 2024. Date of board. It's a paragraph. Next paragraph. By an order dated September 9, 2025, the coordinate bench directed both the judgment debtors, debtors, to file the affidavit of assets in the statutory form as mentioned therein. Full stop. Paragraph. Today, when the matter has been taken up for consideration, Mr.
Balarko Sen. Balarko Sen.
Spell out.
BALARK.
Balarko Sen. BALARKO. Balarko Sen, learned advocate, led by Mr. Subhashish Sengupta, learned advocate, or senior advocate, learned advocate, appearing for the plaintiff decree holder submits that the decree was challenged by the judgment debtors by way of appeal.
Your Lordship, review application and order passed in a Your Lordship execution.
First review, then appeal.
Then order passed.
Oh, the decree has not been challenged by the judgment debtors. The decree has not been challenged by the judgment debtors. Full stop. However, arising out of execution proceeding, one appeal was preferred by the judgment debtors, which was dismissed, and then again a review was preferred, which was also dismissed. Paragraph. In view of the above, paragraph. None appears for the judgment debtors, nor any accommodation has been paid for. In view of the above, the plaintiff decree holder shall serve a copy of the order dated September 9, 2025, along with a copy of today's order upon the Chief Secretary and Finance Secretary of the State of Madhya Pradesh forthwith. The plaintiff shall also serve copies of these two orders upon the concerned branch of the defendant number 1. Full stop. Service, just to serve the order.
Decree has been satisfied
in connection with defendant
Huh?
number 1.
Decree has been satisfied in connection with defendant number 1.
Okay, okay. তাহলে ডিফেন্ড নাম্বার 1টা কি বললাম? ওটা বাদ দাও। অলসো সব থেকে বাদ দাও। Full stop at part. The plaintiff shall file an affidavit of service when the matter shall be taken up next. Full stop. It is made clear that in the event the affidavit of asset as directed by the coordinate bench on September 9, 2025 is not filed positively on or before December 8, 2025, comma, when the matter shall be taken up next, both the Chief Secretary and Finance Secretary may be directed to appear personally before this court. Full stop. Both the Chief Secretary and Finance Secretary of the State of Madhya Pradesh may be directed to appear personally before this court. Full stop. Paragraph. Pendency of this execution proceeding shall not preclude to make the necessary payment under the decree to the plaintiff decree holder in the meantime by the defendant number 2 without prejudice to its rights and contentions. Full stop. Paragraph. Learned counsel for the plaintiff submits that the decree stands satisfied against the defendant number 1. Paragraph. Both these applications, তারপর নিচে লিখুন, both, লিখুন, the instant application along with the connected pending applications shall appear under the one heading, under one serial, under a single item, as a single item in connection with the main execution proceeding on, under the heading আলাদা আসবে না? আচ্ছা, তাহলে কি লিখলাম? আচ্ছা, the instant application, এইভাবে লিখ, instant application along with the connected applications filed in the same execution proceeding shall appear one after another on, under the heading new chamber application, bold করবে, new chamber application on, কবে বললাম ওটা? ডিসেম্বর কবে বলেছি?
8 8 বলেছিল
December 11, 2025. হ্যাঁ কি হয়েছিল? এই রিভিউ ওয়াজ উইথড্রন।
রিভিউ ওয়াজ উইথড্রন ম্যাম।
হ্যাঁ লিখে দাও বাবা, থ্যাংক ইউ সো মাচ। এটা ফেরত দিয়ে দাও। কি দিয়েছিলেন? Is not fine. আচ্ছা তাহলে এক কাজ করবো, ইন দ্য ম্যাটার অফ নেক্সট বলেছি তো, তাহলে ওইটাকে না 8 না করে বলে দিচ্ছি না, হ্যাঁ ওটাকে 11 করে দাও, 11ই ডিসেম্বর করে দাও, তাহলে সব ঠিক থাকবে। থ্যাংক ইউ। নেক্সট।
Item number 9. My lord, this is my lord, this is
My lord, appearing for defendant in this matter, my lord. My lord, praying for time to file, my lord, the opposition in this matter, my lord.
How many times has been granted?
This is the first time, my lord, the is coming, my lord. So praying for 2 weeks time, my lord.
my lord, already 56 days, my lord.
There was
Already
no
56 days, my lord. Service was effective on 15 September.
This is the application. What?
Final judgment, my lord.
For?
Final judgment.
Final judgment. Under
Or
13
13A.
capital A.
Yes, my lord.
Certain capital A.
Yes, my lord.
The amended provision.
Under promise.
Yes.
So 56 days has been already enjoyed, my lord. Service is effective on 15th September, and we are on 10th November, my lord.
What is the bar? What is the bar?
That is within a month they have to file the, my lord.
They have to file?
Within a month, my lord.
Let's see. কি অবস্থা ভাই, প্রত্যেকটা প্রি অ্যামেন্ডেড বই। Place the provision.
Thank you.
না না দাও, আর খুলতে হবে না। Which provisions you are relying upon? 30 days?
That is, there is notice is to be served after, within 30
At
days.
least.
Yeah, at least.
Read.
Book is not here, my lord.
Read.
Book is not here, proof is not here, my lord.
Huh?
Book is not here, my lord.
Where a hearing of summary judgment is fixed,
yes,
the respondent must be given at least 30 days notice.
Yes,
at least.
At least 30 days.
So if I give 50 days, no bar. Or 70 days, it is not a bar. The date fixed for hearing. Notice of the date fixed for hearing. And the claim that is proposed to be decided by the court at such hearing. The respondent may, within 30 days of the receipt of notice of application of summary judgment or notice of hearing, whichever is earlier, file a reply.
So the notice was given on 15th September, my lord.
May. Then again, it is May. Yes, what do you say?
My lord, I want to file a reply opposition to.
Order passed previously in this application?
No, my lord.
My lord, no, my lord. First time it's coming, my lord.
10 days.
My lord.
This is an application for summary judgment filed by the plaintiff decree holder.
No degree holder for the plaintiff.
Huh?
For the plaintiff, no degree holder.
Oh, decree to Haini. Sorry. Plaintiff. Sorry, my mistake. Plaintiff. Paragraph. Today is the first day. Paragraph. Mr.
K.C. Garg, my lord.
K.C. Garg, learned advocate, appears for the plaintiff, stroke applicant. Paragraph. Mr.
Hariram Singh, my lord.
Ki?
Hariram Singh, my lord.
Hare Ram Singh, learned advocate, appears for the defendant oblique respondent through virtual mode. The respondent shall file, defendant oblique respondent shall file affidavit in opposition positively on or before. Positively লিখতে হবে না, on or before. আজকে কত? 10 November 20, 2025.
My lord.
Reply, if any, thereto shall be filed by November 27, 2025. Paragraph. The application shall appear under the heading Chamber Application for Final Disposal on December 2,
Yes, ma'am.
2025.
I must oblige me.
Next.
Your Lord,
Microphone. Take the microphone.
Your Lordship, I pray for a week's accommodation on the.
Why? You are appearing for whom?
For
Is for the applicant, my lord, D1.
I am for the applicant, defendant number 1 in the suit. The advocate
What is your application all about?
It's about condonation of delay for filing of written statement, Your Lordship.
On which day you are filing?
Your Lordship, we had filed on 100.
When 128 days will expire?
It has expired, Your Lordship. The 120 days have expired, but our application was filed before that.
Your application has been filed when?
Just a second, Your Lordship. Your Lordship, we seek a adjournment on the ground of family emergency of the advocate appearing in this matter. I appear only as a proxy counsel.
Passed over for the day. Next.
Your Lordship, item 27 and 28 in the list are also.
Which number is going on, sir?
No, they were connected application.
Next.
Milord, I am opposing this application. Milord, this is my application.
You are opposing your
Yes,
application.
my learned friend is
No,
opposing.
no. This is application. Milad under Order 7, Rule 11, Milad seeking rejection of the plaint.
I appear for the plaintiff. We have served them my opposition. No reply has come. May I file the
Saturday.
Milad, kindly no. Kindly don't take Milad the opposition, because Milad the order was of Milad 21st of August. Milad, they were to file the opposition by Milad 4 weeks. That has passed long back.
Let me
Now, Milad, in the garb of this.
Let me understand one by one. Mr. Dhruvo Ghosh is appearing for the plaintiff.
plaintiff?
Mr. Nirmalno Dasgupta appearing for which dependent?
One defendant.
Defendant, sole
Mr.
defendant, the bank.
Appearing for?
Mr. Sharma and we are together.
You are together, man.
Acha. Acha.
Now, Milad, this suit was filed.
No, wait.
Milad 2.
Wait. You have taken up an application under Order 7 Rule 11.
Right. On several counts, Milad, I'll indicate.
Whatever, that is on merit. To that, the plaintiff has filed an affidavit in opposition.
Not filed. They were due to file. They have not yet filed.
Acha.
They are out of time. I am objecting to that. Milad, for Order 7 Rule 11, no opposition reply is required.
4th of November was the due date.
No, we have filed it.
You have filed it.
No. 25.
We have affirmed
We
it.
have served on us. Milad, kindly see 21st August order. 21st August order, the last order.
देखिए 21st August order देखिए.
That will be CSCOM 63. I will see. That is not worked out without affidavit. Yes. তোমার কাছে নেই
21st August देखिए दाओ.
August.
अच्छा ठीक है.
May I read for your lordship, Milad?
Give me a copy.
8th August order.
अच्छा all right.
Copy দিয়ে
Copy দিচ্ছে print নেওয়ার দরকার নেই.
Milad, kindly see.
September. I think.
Yes. So time has expired.
Kindly see that expired long back. Milad, may I now, Milad? Now, Milad, what they are doing? Milad, there is a section 7 filed by my client before NCLT. Now, Milad, they have filed this. Milad takes up my Order 7 Rule 11. Milad, first of all, this suit is beyond Milad after 2022, clearly hit by Dhanbad fuels. Number one. Number two, Milad, the suit is Milad to resist my Section 7 application filed before NCLT. Now, Milad kindly takes Milad the IBC.
Section 7.
Kindly takes the IBC. Yes, kindly takes IBC once. Kindly comes to Milad Section 63.
Section 7.
No, Section 7 has been filed by my client on the same transaction. Kindly see Milad Section 63. Section 7, Milad as a financial creditor, I have filed Milad bank mortgage, my lord knows. Milad, I have also given 13 to notice under Sadfizi Act. Milad, it is also barred under Section 34 of Sadfizi Act. My lord knows that provision.
Do one thing. I am directing. You've come ready with the opposition.
Yes, ma'am. We have served them a copy.
No, Milad, I have only one right to it. Milad, I don't mind. Milad, kindly observe. Milad, pendency of the suit.
Milad, this prayer was refused. This prayer was earlier refused.
Milad, pendency of the suit. Otherwise, Milad, I have to press for my Order 7 Rule 11.
Mr. Dasgupta
Otherwise, I
was
have to
not
press
there.
for.
Mr.
I'll
Dasgupta,
have to.
kindly bear with one moment.
Maybe I am here. Please welcome me. Milord, kindly Milord observe
Now,
that
when
pendency of the
Mr.
suit.
Das, this prayer was refused by
Pendency of the
Justice
suit.
Krishna Rao. This
Pendency
prayer
of
was
the suit.
refused. Don't raise your voice, Mr.
Both
Dasgupta.
of them can speak together, sir. You have a
Mr.
leader.
Dasgupta,
You have chosen a leader.
this prayer
Sir,
was
you have
refused
chosen
by
a
Justice
leader.
Krishna
Sir, you
Rao.
have chosen a leader, sir. Please, sir, please. May I, sir? Please.
Mr. Dasgupta, I am accepting his opposition. You filed within 7 days on the 8th.
Very well.
On the
I don't mind.
Hear it out.
I don't mind. Milord, kindly record that pendency of the suit will not affect Milord Section 7 hearing. Otherwise, Milord, they will pray for.
I know nothing about the plaint. I know nothing.
Milord, take up. Milord, kindly takes up. Milord, kindly takes up my GO1. Kindly takes up.
Come up on the next day. Come on the next day.
Kindly, then Milord, they should not pray for Milord this shop. Milord, kindly see Milord, what's the prayer in that application before NCLT?
Before CI, NCLT.
12th, day after tomorrow. 12th. This is the floor.
Very well. I will not observe anything. If you have to oppose, you go and oppose the prayer for adjournment.
Milord, they will show this order of your lordship of the extension of the acceptance.
No,
that the matter is pending.
Let me.
Milord, let them not take this advantage.
What is the bar in the suit?
What is the bar? You see, kindly see the book.
Go.
Section 63 is the bar.
Let us. Don't disclose your defense now. Why you are disclosing your defense?
No, Mr. Sharma knows, Mr. Ghosh also knows.
Not get instigated and disclose your defense. Mr. Sharma smiling.
That defense is gone. The law has changed. The law has changed, my lord. We will show.
All right.
Very well. Let them show me. I'm ready, Milord. I want to proceed. Allow me to proceed.
Mr. Dasgupta is always ready, my lord.
একটু পরে 12:20 নামবো, দেখে নেবে, কিচ্ছু না। আমি একটা জায়গায় বলেছিলাম ডিভিশন বেঞ্চের অর্ডারটা সেট আউট করতে, ওটা কোনোভাবে বাদ হয়ে গেছে। কিচ্ছু অসুবিধা নেই, জায়গাটা আমি দেখিয়ে দেবো, করে দিও, কোনো অসুবিধা নেই। তুমি একটু আমার সাথে কথা বলে।
My lord will kindly observe, Milord, 12th hearing should not be stayed due to this.
Praying for rejection of claim filed by the defendant, sole defendant.
Sole defendant.
Filed by the defendant. Full stop. Paragraph. Learned Senior Counsel Mr. Dhruvo Ghosh appearing physically with Mr. D.N. Sarma, Learned Senior Advocate, appearing virtually for the plaintiff, submits that by an order dated August 21, 2025, plaintiff was directed to file affidavit in opposition, but the time has already expired. Full stop. They pray for an extension of time. They pray for an extension. Full stop. Accordingly, the affidavit in opposition, accordingly on the prayer of Mr. Ghosh, the affidavit in opposition filed today in court. Where is it? Filed today in court is taken on record by granting an extension till today. Full stop. Since the copy of affidavit in opposition has already been served upon the defendant, it's a paragraph correct. Since the copy of the affidavit in opposition has already been served upon the defendant shall file its affidavit in reply, if any. You wish to file or you don't want to file?
Milord, they have given me today, Milord, I will have to. But Milord, kindly observe, Milord, this will not, Milord, affect the hearing
Again,
of
Mr. Dasgupta repeating the same thing.
Sir, you have a leader. Sir, you have a leader.
I want to say
Sir, you
something
have a
because
leader.
Mr. Dasgupta was not there. You cannot stop me.
I told you, please welcome me for the first time, sir. You
Yes,
have a
my
leader.
lord, this prayer was
I'm making
refused
this
by the
prayer.
coordinate bench.
Or my lord, kindly takes it up today, Milord, I'm ready.
Defendant
kindly takes it up today. It's clearly barred, Milord. It's a 2025 suit, Milord. How it is maintainable after 2022?
Absolutely.
Without mediation.
You don't use your affidavit in reply.
Kindly takes it up. Kindly takes it up. Very well.
All right. আসো, কি বললাম? The defendant was asked by this court to file affidavit in reply thereto.
No, I'll press it today, Milord.
Yes.
I'll press here and now.
Learned Counsel Mr. Dasgupta, appearing for the defendant, submits that his client shall not file any affidavit in reply
This matter could have been taken up by.
and shall proceed on the basis of the existing record. Full stop. Paragraph. Mr. Nirmalno Dasgupta, Learned Counsel, further submits there is an extreme urgency in the matter as the insolvency proceeding, the hearing of the insolvency proceeding is fixed on
12th,
fixed
day
on
after tomorrow.
November 12, 2025, comma, day after tomorrow, comma, before the NCLT. And this application is required to be decided before that. Full stop. Paragraph. Accordingly, without the affidavit in reply, this court proceeds with the application. Yes.
Kindly take similar the plaint, GA1.
Slowly, slowly,
Yes.
slowly. Where is Mr. Sharma?
He is sitting beside me, Millard, in NCLT.
I'm here only. I'm here only. Madam, Mr. Dasgupta is unnecessarily raising his voice, madam. It will. There's no need to raise his
You
voice.
don't press for the stoppage of the
Please don't.
NCLT proceeding,
I am
my lord.
addressing the court. Please don't talk to me.
Dasgupta,
Maintained.
don't fight anymore.
Yes.
Yes, kindly take similar the GA1.
Slowly. I'm not that fast.
Yes.
Go slowly. GA?
1.
Not
Like
1.
GA2. Sorry, Millard. GA1 is their injunction, which they have not pressed.
That's why I'm asking you to go slow. Slowly.
GA2, yes.
Where is the plain page?
Yes, my lord will come to the plaint at page Millard 30.
30.
Now, Millard kindly come to Millard paragraph 3.
Let me see the plaint.
Yes, paragraph 3.
No, paragraph 1. Let me see.
Achha. Paragraph 1.
What is the total claim according to you, Mr. Dasgupta, as of now, as on the date of filing of the plaint? Approximately.
The cash credit facility was to the tune of rupees 95 crores, and the bank guarantee was to the tune of 130 crores.
So let's say 225 crores.
Roughly.
Yes. Now you proceed in your own way. How will you proceed with the plaint?
Yes, kindly Millet C has seen Millet paragraph 3. Millet, each and every Millet paragraph will Millet show that Millet this is the plaint to resist my Millet section 7, which I have filed, and I will show the application that they have filed with the NCLT. Now Millet kindly takes Millet note of paragraph 3. I'll just show the paragraphs. Paragraph 3. Then Malul kindly takes Millet paragraph 8 at page 34.
Wait, slowly. 3, then 8.
Yes, 13 to notice has been issued under SARFAESI Act. So Millet apparently barred under section 34.
Show me, have you annexed your 13 too?
13 to Millet, yes, let us see. It's let us see.
From an application, show me.
Yes. Page 63. 13th October 2017. October 13, 2017.
Claim.
Page 63.
What is the total claim?
Millet claim. All the securities as given. Yes, Millet will find at page 72, paragraph 5.
Yes, I'm on that paragraph itself.
Thereafter, very well. Thereafter, OA has been filed under section 19.
Wait. Yes, 72.
Then 73, OA Millet, first order of Millet OA. Last order of OA, 21/2025.
Page?
It's the next page, Millet. Just next, 73. Now Millet kindly takes page 74.
Wait. Yes.
Millet at the parties Millet entered into a Millet OTS Millet the one-time settlement at page 74 in 2021. prior to all this.
This is
And Miller,
what
prior
is
to all this.
it's 72.4 is the OTS.
74 is the OTS. As my lord knows, Miller, the time schedule is being framed in every OTS to pay off the debts. Miller, those who are not adhered to.
Where the time schedule?
74, Miller 74.
Where is
Kindly
the
see up front, Miller, see serial number 1, up A, B, C, D, E. Miller, not adhered. Miller, when the OTS was entered into, there was a first Section 7 proceeding filed. We had withdrawn the Section 7 before the NCLT on the basis of the OTS in 2022.
2022?
That or 2.
First Section 7.
Section 7, yes. Kindly takes page 77. Miller, after the OTS has failed, we had to go.
Wait, I'm coming within 5 minutes. 5-6 minutes. I'm coming, Mr.
Continuing matter, item number 11.
Yes.
Now, my lord will kindly see. My lord has seen page 74.
Yes.
Then my lord had seen the order of NCLT. That my lord we had withdrawn. Then my lord they have failed in paying off their dues as per the OTS scheme. Now, Millard, we have went back to NCLT saying that Millard kindly revive Millard my earlier section 7 proceeding, which NCLT has said that proceeding cannot be revived, you file afresh. Now, meantime, kindly comes to page 95. Millard, a fresh OTS was given.
No, you tell me whether your fresh section 7 has been filed.
Filed, they have been taking adjournment due to the pendency of the suit.
Fresh section 7 filed one. When?
Millard, kindly in 2024. Filed in 2024, Miller, I have to Miller see the exact date. It's CP number 98 of 2024.
Very well. Then what happened?
Now, Miller, we had filed a fresh section 7 because Miller, they have again filed, Miller failed in their obligation of OTS of the second OTS.
Where is the second?
Now, Miller, page 94.
'94.
94.
It's a chart, table.
No, it's a letter from the bank.
94 is a table.
Yes, 95. Sorry, 95. Next. Let's 27th September 2023. My lord will find it the reference there various letters. At the first page, my lord will find the details, the conditions given.
Yes.
Now, this OTS has also they have failed. We filed the second section, fresh section 7. Now, Millard kindly comes back to the body of the plaint again.
Yes.
Kindly see paragraph 12. These are all admitted facts.
12.
These are the facts which I have already submitted before your lordships. No, Millard, no difficulty with those. 12, 14, 16. Kindly, Millard, note the paragraph.
What are those?
Millard, those are the Millard facts which I have submitted to your lordship, Millard, pertaining to the NCLT proceedings. Kindly see, Millard, paragraph 16, 12, 14, 16.
Yes.
Defendant bank had approved the NCLT on 12th May 2022 to withdraw the company petition under section 7. So, Millard, I am not bothering your lordship with because I have already submitted on this. Now, Millard kindly comes to the Millard 23. Also takes note of paragraph 18 once, Millard, then Millard kindly comes to 23. And we'll get the dates also, Millard, in paragraph 23. First May, the matter was taken up first, the new section 7. Paragraph 23. Paragraph 23. Might will get the date also, Millard. 1st May 2024. Now, Miller kindly takes 39. Their urgency, contemplation of urgency to deviate 12A. This is the urgency shown. 39. As the defendant bank, kindly see Miller.
Wait. Thirty.
39.
12A dispensation done.
12A dispensation done.
Injunction passed.
No. GA1 Miller, they have Miller filed. They have not pressed for GA1. We have filed our opposition. They have not pressed for injunction. That is recorded. Miller, initially they had filed a suit.
Okay.
Justice Rao was of the view, Miller, otherwise I'll be failing in my duty. Miller, initially they had filed a suit. Justice Rao was of the view that they should go back to Miller the mediation and they should Miller come back after Miller complying with Miller 12A. Now Miller, that suit was withdrawn, returned back. So Miller, that has lost its force. Now Miller, they have filed a fresh Miller. We have Miller the Miller. Then now Miller this fresh suit was filed.
Have they gone for pre-litigation mediation?
Miller, in that Miller they have gone.
Non-starter report is there.
Non-starter report is there with regard to that portion.
Huh?
With regard to that, the first suit, which Miller was returned back. Returned back.
Then they went for mediation. Failed. So
now
the
Miller
report is there and this suit has been filed.
Now Miller, kindly see paragraph 39.
There is as of now irregularity in filing this suit.
Irregularity. Kindly comes to paragraph 39. See the urgency. As the defendant bank is proceeding with the NCLT matter, when the plaintiff has no remedy to ask for specific performance of the agreement dated such and such, plaintiff had no time to initiate a conciliation proceeding in terms of section 12A of the Commercial Courts Act, and such exemption was prayed for through the Honorable High Court on such and such, and the same was moved before your Lordship Justice Miller, Justice Rao on 25th February 20, whereby prayer for exemption was rejected. However, the plaintiff's court fees was returned.
Then that's
Then
all.
Miller mediation failed.
Let's not go into that. The suit,
Very well.
the board.
Very well. Now, Miller, what is the basis of the suit?
Of the Commercial Court Act.
Right. Now, Miller, kindly comes to the prayer.
It is maintained.
Very well. Kindly comes to the prayer. Beliefs at page 53.
Yes, 54.
54. They are seeking enforcement of the OPS, which they have failed. And a section 7 is filed. OA is filed before DRT. This is clearly barred not only under IBC, under Miller SARFAESI Act also. Miller, I did not show SARFAESI to your Lordship.
34.
34. But I told Miller not to bring SARFAESI Act.
These are your
34.
These are your
no, Miller, kindly see section 63 also of IBC once.
IBC. No, wait.
63.
Yes.
Civil court not to have jurisdiction. No civil court or authority shall have jurisdiction to entertain any suit or proceeding in respect of any matter, just like section 34. Any matter on which NCLT or the NCLAT has the jurisdiction under this court. Civil court not to have jurisdiction. Milord, what more? Their prayer is straight milord into hitting into NCLT proceeding.
Now you show me the procedural provisions of that IBC.
Milord, I'll come to that. Kindly see their application filed before the NCLT once. Minor will get their application seeking stay of the NCLT proceeding. Kindly come to 218 volume 2.
Our volume 2, order 7A.
This records milord at 2 milord. We have annexed the plaint only.
All right. Which page?
218. I will not show anything. Kindly come to at 227. Reliefs.
218.
Yes, it starts at 218. Kindly come to 227. Kindly see the sole release.
Yes.
Kindly see prayer A. Prayer A. Relief sought for prayer A.
Yes.
Stay of the present proceeding.
Read.
Stay of the present proceeding being CPIB number 98 of 2020 till disposal of the application GA1 2025 of CS.Com 63 initiated by CD against the financial case before the Honorable High Court at Calcutta. They have not pressed for the injunction and kept the matter just pending. And this matter is fixed on 12.
Order passed in GA1.
Yes, Millard, that order was passed in GA1. Kindly comes to Millard. The order is yes.
In the NCLT?
Yes, kindly see 12th August order of your Lordship's court.
NCLT is there? Not on matter. Some places are reserved for doing these matters, doing virtual matters.
I've never been. Apparently, it's out of town. Huh? Yeah, there's a bar room.
Because they are doing, both of them are doing in such a relaxed manner with the revolving chairs and all.
No, we are sitting in separate rooms because Mr. Dasgupta's voice is so high.
You do matters, the sitting doesn't matter to the court. But you are so relaxed in the room, that's why I am saying. And in the meanwhile, coffee, biscuits are also available, or what?
Yes.
That has been installed.
Coffee
We
machine
have a
is there.
canteen also Millard at 7th floor, but Millard, we
All right.
usually don't have those.
27, yes.
Mr. Dasgupta has no time to go to the canteen. He's very busy. As of now, he is not gone.
Right.
No, I have not gone. Millard, I have not gone.
27.
Millard, kindly takes Millard 12th August order.
It might that happen also like that he cannot go to canteen because you do not treat him as senior.
He doesn't have the time. He always comes and rushes. Today only I'm seeing him doing a matter so patiently.
Next, yes, 227.
Millard, kindly see Millard 227 I have shown to your Lordships. Millard, kindly see 12th August order of your Lordship's court.
12th August. Where is which page?
No, that is in my Lord's Millard records. Millard, it's 5 Millard order 12th August order.
Order now. Give me a copy of that order. 12th August. 12th August
2025. Basically, Millard, no order passed in GA1. They have also not proceeded to Millard obtain any order. Just pending, kept pending. Like today, Millard, it's also appearing today even down the list. and they are seeking a relief.
Where is the first order?
First order of
26th of June.
28 July. 28 July. 28 July.
6th of June.
No, before that.
6th of June. Acha, 6th of June.
26th of June.
26th of June. 26th of June. So they have not also pressed for it. Kindly see the order, feel.
Yes.
Their intention only to keep the GA1 pending. They don't want any order. That's the order. Pendency is the order.
Next, make your submission. Proceed.
So these are in my submissions with regard to the GA, the application. Kindly come to the AO, opposition file.
What more you can submit in Order 7, Rule 11?
I don't want to, only see their opposition, my duty, to your lordship, to show their opposition also.
Yes.
They have not made out any case which will can digress your lordship's mind to any other 7x dismissing it. Kindly takes the affidavit in opposition.
Yes.
They have from paragraph 4, as usually deal with before dealing with same thing has been copy pasted from plaint. Kindly see mark the paragraph number, same plaint.
Now you come to reply to one of my queries.
Yes.
Take me to the insolvency code and show me what is the, because if you file section 7, whoever
Yes.
filed section 7,
yes,
and then what is the jurisdiction of the IBC to adjudicate?
File section 7 kindly comes to section 7 once It's self-explanatory. The court will the adjudicating authority will only see as to whether.
Slow. Initiation of corporate insolvency resolution process
by a financial creditor.
Right.
This is a a loan given, loan obtained. So FC.
Secured creditor. Come on.
Secured creditor, right? So kindly see only the court will see whether the record is complete or not. The petition is in form or not. If the petition is in form,
wait. Any corresponding rule? IBC rule?
There is a rule, but rules are at present are not applicable. It's only on section 7.
No.
Rules will come when it will be admitted.
Is there any rule?
Yes, rules are there. Rules are there.
Regulations.
Show me that
CIRP regulations.
The relevant procedure for section 7. What is the procedure for section 7?
That Millard I'm going through. Millard, only thing is that Millard at present, before admission,
see changes in the bankruptcy code have come after my elevation. So I must know that.
Millard, with regard to CIRP regulations, Millard, those only comes into play after it is admitted. And IRP is appointed.
Is the Mr. Sharma?
My lord, there is an adjudicating authority rules which has to be shown.
Right. Can you show me that any rule prescribes any procedure?
Yes.
For section 7 hearing?
Yes. That no procedure
is only section 7.
Oh, please, Mr. Dasgupta, I'm asking one question.
Achha, very good.
Procedure for filing is there in the rules. How to when and how to file section 7. That procedure is given.
A very specific question. When section 7 is filed, is there any coded procedure that this way this will be heard?
Yes, that is mentioned in the body of section 7.
That is only in section 7 only, my lord.
Oh, very well. That I have read. I know that.
That's only. No.
Please.
That
Sharma, other than any there. Other than that.
Lordship, I read section 7, subsection 3 and 4.
I have seen that.
Other than that, there is no procedure.
That's all.
Only for filing it is there, not for hearing.
That's all.
That's all.
Yes. Now, Mr. Dasgupta, these are all?
Yes, Millard, I have shown the AOs. These are all.
Any judgment you want to cite?
No, Millard, with regard to provisions are clear. Section 63 and 34 of SARFAESI Act.
Some Dhanbad, you are covered by 2025 Dhanbad. He said it when he opened his case. I have looked it up. It's not relevant, but it was just said that it was so urgent.
No, I thought that it is not required.
Dhanbad seals of fuels.
Dhanbad fuel.
Dhanbad fuel is not relevant because we have already gone through 12 days.
When before
started, yes, just before today only. He said, "I'm totally covered under Dhanbad fuels. This plane will have to go."
Yes, we also heard that.
That now, so I'm happy he hasn't argued it because it's not applicable at all.
Dhanbad I have read after sitting in this jurisdiction.
It's about
I have read Dhanbad.
section 12A.
Very well. Now make your submission, sir.
So before I begin, I'm at a dilemma on how to begin, because what is the bar under Order 7, Rule 11, which is the bar under law that my learned friend is saying. My learned friend, the only relevant submission, as it were, was that Section 34 of the SARFAESI Act, or 17 of the Debt Recovery Act, or 63 of IBC. So we had to show that my suit could have been filed in any of these two things. That can my suit have been filed in any of these tribunals, or is there a bar for me filing this suit, even if it is by way of a counterblast to their claim? And the law is now settled that I can file a counter suit for whatever jurisdiction, whatever cause of action in the High Court as a civil suit. Your Lordship may recall when we started the profession, Obijit T came in and said that no, you even your counterclaim, you have to file a suit. If I have, this is in the sense it's like that, because the bank has agreed to 90 crores, they had agreed to our OTS. We paid 55 crores odd, then we failed. Then another OTS, another agreement was made, 55 crores. Then when we agreed to that, they said, no, we'll increase it by 1 more crore, you put in. So we put in that crore. And even after that, then again, they wanted some more money. So we filed the suit saying that you're in breach of the agreement that you made for 56 crores. This is my suit. I could not have filed it before the IBC. Let's start with that. Now, the thing is, does my suit, is it barred under IBC? It's not barred. Your Lordship was seen Section 7. I couldn't have filed a suit asking for a declaration against a party. I'm not claiming any debt. The IBC, the preamble wasn't shown. It's for a specific purpose.
My first thing, what I'm thinking, can an OTS be enforced by way of a civil suit?
Yes, it's an agreement. That's the way.
It's agreement
Between two parties, it's an agreement to novate or to change the whatever the earlier situation was.
But that point,
it's not without prejudice or something extraneous that has happened.
That point, then, can it not be assuming that your suit is maintainable, assuming for the time being?
Then specific performance of a contract. That's what I've asked.
First, kindly come to. That's why I was asking. Kindly come to.
So, if I may finish that bit, my lord, OBG 3, your lordship may recall, counterclaim had to be made.
Yes, ultimately it was held. DRT has jurisdiction to entertain counterclaim.
At that time, this is 25 years ago. Then, my lord, came the ABS Marine. ABS Marine, where Justice Indira Banji said, no, you can file any suit here, but under some conditions, this suit can be transferred back to DRT if it fulfills certain. Now, that has been completely overruled by the Supreme Court, and it says that I am at liberty to file a suit under Section 9, no matter what. So, the entire law has changed, and it basically interprets this Section 17 of the RDDB Act, my lord. That I want to place, and it's absolutely parameteria with the IBC.
Show me.
So there is no so what is the bar? My learned friend has only said these 2 points of law, that it's this section. And the 2 sections are identical in the language, IBC and the RDB.
No, I am on whatever. I'm saying that.
The bar that he has claimed is the entire morning was spent trying to prejudice my lord to say that your lordship will make some observations that I can't use this proceeding to stall their proceedings.
As a tool.
That doesn't make it a bad suit in law. If I can use it, if I can't use it, that's for that jurisdiction to decide. It's not that I've asked for an injunction of their proceedings. Let them proceed. If
that you cannot, it's hit by specifically fair.
Obviously.
No, kindly,
The section reads, no civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which a debt recovery tribunal or appellate tribunal is empowered by or under this act. They are empowered to adjudicate financial institutions' claims.
No. And so long, Mr. Ghosh.
And to determine, I'll just place it, and no injunction is to be granted by any court in respect of the actions taken by them. I have not asked for an injunction.
No.
I've asked for, before that court, I've asked for a prayer for the discretion that they will hold. And that application has been, I believe, disposed of. No, we have not got any order on that application.
Which one?
The application that was shown last that I've made before the IBC, saying that I filed a suit and my application is pending.
Oh, that's not pending anymore.
I don't know if it's pending, but we didn't get any order.
Well, that's pending. They have been taking time on that due to the pendency of the suit.
Your lordship's query.
That is fixed on 12.
One second. Let us read this section 63.
Yes.
IBC.
Yes.
No civil court or authority shall have jurisdiction to entertain any suit or proceeding in respect of any matter on which National Company Law Tribunal or National Company Law Appellate Tribunal has jurisdiction under this code.
Yes.
Civil court.
Now, my lord will come to the preamble. What is the jurisdiction of these tribunals?
Yes.
An act to consolidate and amend the laws relating to reorganization and insolvency, resolution of corporate persons. I'm not asking for that. Partnership firms and individuals in a time-bound manner for maximization of value of assets of such persons to promote entrepreneurship, availability of credit and balance of interest of stakeholders, including alteration in the order of priority of payment of government dues, and to establish Insolvency and Bankruptcy Board of India and for matters connected therewith. It's not a debt recovery tribunal, though it's used obviously from time immemorial.
What I am on, kindly come to subsection 3, section 7. First two. Subsection 2.
Financial creditor shall make an application under subsection 1 in the form and manner. Yes.
Right?
Yes.
So it's the initiation of the proceeding by the financial creditor.
Yes.
Right? So he comes up with an application. It may succeed, it may fail.
Yes.
Next. Financial creditor shall all along, the application shall furnish. I'm not going to that. 4. The adjudicating authority shall within 14 days of the receipt of the application under subsection 2 ascertain the existence of default from the records of an information utility or on the basis of other evidence furnished by the financial creditor under subsection 3, provided that if the adjudicating authority has not ascertained the existence of default or passed an order in subsection 5 within the such time, it shall record its reasons. That's the procedure.
Yes.
Forget it. Let's not get troubled with that. So it has a jurisdiction which is a mandate under the statute. It has to ascertain the existence of default. How? From the records of an information utility or on the basis of other evidence.
Yes.
Now, you will be granted an opportunity to file affidavit before IBC.
Yes.
Correct? What will be your defense, sir?
There is a agreement.
Concluded, there is a concluded
agreement.
Concluded
Yes.
OTS.
Yes.
Whatever evidence, because this or on the basis of other evidence. So whatever evidence you have, you are entitled to file there by way of affidavit.
Maybe.
On the basis of your case on record, your contention on record, the adjudicating authority must come to a finding with reason. Either he has to accept it, that you have a case,
Yes.
right? Give reasons. In that case, if he finds you have a case, then automatically 7 might fail.
Yes.
Correct? 7 might fail. He might come otherwise with a finding that you don't have a case. Then you will have to also give a reason. Then 7 can succeed on the board if they reject your case.
Yes.
I'm not on the subsequent procedure, Mr. Ghosh.
Yes.
So why civil suit? This plea you can take well before the tribunal.
If I may put the question, what is the bar for the civil suit?
No.
There is no bar.
No, may not be. But, again, let us, in the light of this, let's read
Yes.
that section of appeal. I mean, sorry, the bar.
Yes.
63. Have you got? Yes. No civil court or authority shall have jurisdiction to entertain any suit or proceeding in respect of any matter on which NCLT or LAT
has jurisdiction under this court.
So
then does NCLT have jurisdiction to hear my claim?
Sir,
or I can make a counter claim or a counter suit.
Sir, Mr. Ghosh.
Yes.
The way you have framed the suit,
yes,
you can take the same plea and same defense because of subsection 4 before NCLT.
Yes.
If NCLT is satisfied, it gives a view, yes, nothing doing. 7 is absolutely frivolous because a conclusive settlement OTS is there. It cannot at best direct. It cannot direct you to,
they cannot give me specific performance.
They cannot
dismiss
direct you, they cannot direct you to keep your promise in terms of OTS. Whatever you have agreed. If they come to a finding, it's conclusive settlement. But of course, they can reject 7.
Yes, they can either allow the 7 or reject the 7.
That's all.
So my claim, as far as my suit, I'm asked for declaration that the acceptance of consideration by the bank, which I had paid, 2 crores I've paid extra. I've changed my position against the enhanced offer of OTS proposed by the plaintiff has resulted in a
Now let us see what is the
contract.
relief, sir, from
Yes.
your plaintiff.
Page 54, man.
Yes.
Of GA2, page 54.
Let's see
Sets
the
out the
relief.
prayers.
Prayer A.
Yes, ma'am.
A decree for declaration that the acceptance of consideration by the defendant bank
Against the enhanced offer.
such and such has resulted into a concluded contract.
From 55, they went to 56. I paid.
Mind, sir. I don't mind, sir.
Yes.
I'm not going into that.
Yes. Then specific performance.
10 or X to Y, whatever.
Yes, X to Y. Then after that,
if you take this plea,
they are denying this. That's why I need a declaration.
No.
They are denying this
No,
by
sir.
filing the IBC.
Mr. Ghosh,
Yes.
if you take this plea as your defense,
Yes.
and if the NCLT holds your plea successfully,
Yes.
gives its reason, 7 fails. 7 fails.
Yes.
Now come to page B, prayer B.
Yes.
Decree for specific performance of the contract. Specific performance of the concluded contract between such and such, such and such. Definitely it cannot be granted by NCLT.
No.
Correct. But you are successful before NCLT. The moment 7
I still have to pay the money. And he'll still have to perform the accept the obligation.
I am not on that.
Yes.
The moment 7 fails,
Yes.
you succeed before NCLT. Matter ends.
Before NCLT, but matter won't end.
Matter won't end.
But the DRT proceedings are pending.
Then of course these plea can be taken before DRT. Then these pleas are maintainable. Are maintainable before DRT.
Of course they are, but they are not.
That's why I have taken first the 7 pleas, IBC, then I'm coming one by one.
Yes.
Then prayer B.
Now the law says that I can file an independent suit. I'll just
Yes, I read that.
Yes.
Of course. No, first let us.
Of course, that there'll be the facts won't change in 2 tribunals.
Let us first complete the prayer. So according to me, if you succeed with A before NCLT, 7 fails, you succeed.
Yes.
Then according to me, prayer B, you can take well within the jurisdiction of section 17 where it is filed. The jurisdictional DRT. Right?
Very well.
Then C, permanent injunction, that's the result.
Yes.
That's the result.
And then
if your 17 plea, 17 counterclaim succeeds, it's automatic.
It's not, because there are 2 proceedings against me, DRT and IBC.
No, but IBC, if you succeed,
If I succeed, I can dismiss that on a technical ground. Also, I can dismiss it. That doesn't mean it goes away. The problem.
No. But section 7, if you succeed on your prayer A,
yes,
prayer A in the plaint, 7 this stands dismissed.
If I succeed, if I get the declaration,
of course,
yes. Now, prayer D, your lordship will see all these letters. The bank is denying that the OTS exists.
Mr. Ghosh,
I need the declaration also.
No, twofold there. These letters within the meaning of other evidence. This letter within the meaning of other evidence under subsection 4 can be considered and taken by the NCLT.
They cannot be delivered up and cancelled by the
Absolutely,
NCLT.
I agree, sir.
Yes.
But those can be done in 17 proceeding before DRT, coupled with your prayer B. Coupled with your prayer B here.
That I'm not going into, I'm not committing to that. But, my lord, it is completely irrelevant because of the state of the law as of today. Now, if I may cite that.
Now you cite whatever judgments you want to cite.
Yeah. And this is reported in 2023, 1 SCC, page 1.
Madam, take note. 20.
Yes. So, my lord, in this matter, the reference was made to the Supreme Court I think it's 5-judge, three-judge bench of 2 decisions of the Supreme Court relating to this issue. If my lord sees the page 8, the beginning of the judgment, the present reference arises from
wait, sir, wait.
Page 8. The long head note.
The page 8.
Sanjay
Kishan, page 8.
Yes.
Paragraph?
The first, just the beginning of the decision. Sanjay Kishan call. The present reference arises from a question mark over the legal right of the borrower to initiate proceedings before a civil court against the bank or financial institution which seeks to recover a loan amount against it. This is nothing to do with IBC, but they first initiated before DRT. And the same principles in my respectful submissions will apply to.
Let's read once again, sir.
Yes.
The present reference arises from a question.
Question mark. Over the legal right.
Over the legal right of the borrower
to initiate proceedings before a civil court
against the bank or financial institution which seeks to recover a loan amount against it. Yes. Show me the press in the plaint.
My press. I showed.
No. Judgment.
This is a reference. We have 2 decisions. Some decisions said that you cannot. Then the decisions came. Then the decisions came. Yes, you can. But under certain circumstances, it can be, your lordship can direct the transfer of this suit. Now, this this decision which I'll place before my lord will say that even now your lordship cannot send it back there, even if it could have been sent. So those conditions that were put down by Justice Indira Banerjee, my lord, here ABS Marine, which went up and was affirmed in the Supreme Court, those are also, since for paucity of time, my lord will just come to the last paragraph once.
No paucity. I will take up at 2 o'clock.
I have an appeal before Justice. The commercial is over.
You're junior?
I want to place this, my lord. Lordship will take it up tomorrow. At 2 o'clock, if it commences.
No, I don't fix it.
No
time I will fix.
Because now with Justice Boshak, there's no chance of escaping. I have actually fixed my appeals from today and tomorrow, my lord. But anyway, if your lordship comes, before your lordship rises, just the conclusion, paragraph 59 and 6, page 30.
1 second, hold. 59?
Paragraph 59, page 30. The last paragraph of the judgment. Just to tell my lord what is the
principle laid down.
What happens. Then the civil appeals are dismissed. The bank's appeals were dismissed. The judgment of Obijit and Ranjan Chemicals are held not to be laying down the correct proposition of law. The judgments of the Indian Bank and Nahar are affirmed except to the extent they allow transfer of suit. So no transfer.
So Nahar said counterclaim is permissible.
Nahar and Indian Bank.
From my recollection,
yes, they said that a separate civil suit is maintainable. But the High Court has the court has the jurisdiction to send it back under certain conditions and to be treated as a counterclaim.
That is not permitted.
That is no longer permitted because you have a full right. If you file a civil suit, that is allowed. So OBGT has been overruled. So the law has changed completely. The lordship will see paragraph 56. Just in view of the discussion aforesaid, the questions framed above are to be answered as under. Is the jurisdiction of a civil court to try a suit filed by a borrower against a bank or financial institution ousted by virtue of the scheme of RDB to the proceedings of recovery of a financial institution? The aforesaid question ought to be answered first and is answered in the negative. It is not. So ousted, the civil. Then A, whether an independent suit by a borrower against a bank which applied for recovery of its loan against the plaintiff under the RDB Act is liable to be transferred and tried along with the application of the DRT. Then the answer is, in the absence of any such power existing in the civil court, an independent suit filed by the borrower against the bank cannot be transferred to be tried with an application under RDB, as it is a matter of the option of the defendant in the claim under the RDB Act. However, the proceeding under RDB Act will not be impeded in any manner by filing a separate suit before the civil court. If the answer is in the affirmative, can such transfer be ordered by the court only with the consent of the plaintiff? Since no power, since there is no power with the civil
confer jurisdiction.
You cannot. The question of transfer by consent.
Transfer, Mr. Ghosh.
No, this is it. What fell from, because OBJT for the last 20 years, we have, this was our impression that we would have to go there if it was thing. But now even that I don't have to explain whether or not this thing would have been entertained. And the same.
Can you show me the prayers in the subject suit?
Yes.
Has it been quoted?
Yes, I'll tell I'll just tell you.
Paragraph 5. Paragraph 5.
Yes, paragraph 5 is the prayers. Well, first it says the Bank of Rajasthan filed DRT proceedings. Then paragraph 5, a crucial development took place in March 98 when the appellant sold the pledged shares for a total sum of such and such. The respondent in sequitur filed a suit before the High Court praying for declaration that the sale of shares was void. So the pledged shares had been sold by the bank and that was challenged. This case will, I think we have a sound case as far as the maintain. Now we are only on Order 7, Rule 11. My learned friend has done the best to try and prejudice my lord that we are trying to stall their proceedings. That if we are entitled to, we will. But as far as the maintainability, nothing was said about it. It's only said that we have filed a proceeding there and the NCLT has jurisdiction to decide a civil suit. I don't think so. We'll cite more, one or two more decisions.
Tell me when. Yes. Tell me when.
Because day after is
day after is the proceedings before the NCLT.
The list, but if only if I'm stuck, they will keep it at 2 o'clock.
I don't
because 2 o'clock there's no.
I don't believe in fixing time. I don't believe. If I proceed with the list, I will proceed with the list one by one, sir, Mr. Ghosh.
Then you keep it.
But
I'll try my best to be here.
No, of course. That's not a problem. Not a problem. If I have to continue the hearing, then I have to continue the hearing and
interim order. They will go on the proceedings there.
Yes. Then for that the fixation before NCLT will not matter to this court.
Yes.
শুনতে পাচ্ছে না তো?
No, Millard, I can hear you, Lordship.
For that, whether the matter is fixed or not really doesn't matter to this court. It's a point of law. I have to hear and decide. So whether the matter is fixed or not, and it is nothing such a matter that if it is not taken up, the heaven will fall immediately on day after tomorrow. Very well. Yes, tell me.
Then
when?
Wednesday. I can't ask for more.
Yes, Mr. Dashgupta and Mr. D.N. Sarma. Yes.
I can hear you, Lordship. Yes.
Mr. Dashgupta, tell me when. Come day after tomorrow.
Very well, Millard, I don't mind. But the only thing is that only to.
So let me be very candid. It hardly matters to this court whether the adjournment will be there before the NCLT for this reason or not. Because I am hearing a point, I have to decide it. I have to. That's my way of thinking. I have to give a hearing to both the sides. I will
Millard,
also.
If that be so, Millard, I have not filed my reply because of this reason only. This reason only.
That is up. That's your call.
I have taken that call. I have taken that call under the impression that this will be completed. Millard, he has not indicated to your lordship that he has fixed matter after 2 o'clock.
That neither is not there. That's your call. I have granted you opportunity to file.
No, I was under the impression that he will complete today. Milord, I have completed it at the earliest I could do.
There are so many ifs and buts for which this court will not move.
Then if my lord day after tomorrow is gone, then my lord can keep it comfortably also. That doesn't matter. That doesn't matter. Then
Day after tomorrow is comfortable.
Yes.
No problem.
Yes.
I'll hear you all. You come ready. Better do one thing. If you want to rely upon more citations, give him in advance. The cases give him in advance so that he can come prepared and reply.
Now he's got one. Let him deal with
yes,
this. That's
yes,
my
he has
main
got
stake.
one.
Yes.
If you want to cite 2, 3, whatever, you are free to cite it.
Very good.
Give them so that in advance so that he can come up ready.
Milord, may I mention item number
No.
35, 36, Milord?
I mean, he go orderly.
Milord, also 33, Milord. This section, item 11 and 33 are the same matter.
33 is our GA.
And item 11 is there, order 7, rule 11.
yes, 2 applications. Both can be taken up, Milord, together, Milord.
Yes, that will remain in the list if I cannot reach today.
Very well.
Asho. এই ম্যাটারটা
in GA2.
হ্যাঁ ঠিক আছে তারপরে লিখুন Mr. Nirmallo Dasgupta has concluded his submissions on behalf of sole defendant. On behalf of the defendant, full stop, paragraph. Mr. Dhruvo Ghosh, Lane, senior advocate, has commenced his submissions. Full stop. He has referred to a judgment of the honorable. He has referred to a decision of the Honorable Supreme Court in the matter. He has started placing reliance on a decision of the Honorable Supreme Court in the matter of in the matter of bold italics করে যে এটা লিখে দিন Bank of Rajasthan versus VCK shares reported at এটা একটু লিখে দিন এখনই লিখে দিন
Order.
And in any event, what more you will improve in your reply? Because these are the point of law.
No, Milord, I was only thinking aloud, Milord. There has been some amendments, formal dispute denial. I have given away my right because under the impression that they will complete it.
So you
That's only I'm thinking.
Come up tomorrow at best with a reply. Come up day after tomorrow.
I'll try my.
Yeah,
Milord, my.
That part I'm modifying since at your behest matter is again. এবার লিখুন
Milord, in that event, Milord, kindly keeps it on 15 because Milord, Mr. Saurabh Mukherjee is leading me. The Sat ceremony of his father is on today and tomorrow. So he'll be joining court on 14th. So Milord, kindly keeps it on 15. Then Milord, he will be joining, Milord. So Milord, he is the pioneer of this proceeding. So Milord, let him come.
জশব দেখে নেবে
না ও কিছু বলে গেছে কি লিখেছে
তাহলে 16 17th হবে তাহলে 15th তো স্যাটারডে
লাস্টে কি বলেছে 17 he has relied on such and such paragraph. Mr. Ghosh, Lanet senior counsel, then prays for an accommodation for the day and tomorrow and submits if the matter can be taken up day after tomorrow. Paragraph. In view of the above, the first part of the order where in view of the above, Mr. Nirmallo Dasgupta, learned counsel, appearing for the defendant, on instruction from his clients, makes a prayer that since the since the hearing stands adjourned for the day, his client shall file an affidavit in opposition. Reply. Paragraph. Accordingly, the defendant shall file affidavit in opposition.
Reply.
on or before affidavit in reply on or before আজকে কত 10 তো
And he will be joining on 14th.
November 13 reply
Mr.
November
Mukherjee will be
13
joining. Milad, any of Milad is keeping it. Milad, I was praying. Milad, Mr. Mukherjee will be joining. Milad on 14th.
the hearing after that but reply by 13th.
He has to see. He is Milad leading. Milad, he has to see.
Reply by
One day more. Milad can help us. Milad.
November 15 November 17 2025 the matter shall appear under the heading কিসে আছে
He
চেম্বার
has to retain his position. Milad. Let to retain his position. Milad has had it. Milad come. Milad mostly. So otherwise, if it goes round Milad, then Milad.
under the heading for orders
Very good.
under the heading for orders on
17th. 17th. Come back on 17th.
no, fifth কবে অবধি দিলাম রিপ্লাই
70.
on
Achha. Any day.
November 18 2025 November 18 2025
Obliged.
I have lived to
paragraph
So sorry, Milad, for bothering your lordship. Milad,
the first part of
with the application.
accordingly the first part of the order stands modified.
may I permit to mention a
Deeply
matter?
obliged. Deeply obliged, your lordship.
My lord,
We have taken a milestone time for the recess.
should not have been done একটা সাদা ফাইল করো তাতে এইটা
Lordship will not take up the list, not urgent situation.
Take the microphone.
Before your Lordship takes up the regular list, I have to mention an urgent situation, Miller. The matter where your Lordship had passed a judgment regarding filing of written statement in the same matter for another defendant. I need a similar leave to file for short service of the master summons. I have filed the application. I have taken out the application. It's affirmed, but unless the leave is granted,
no, affidavit will have to be stamped and punched.
Yes, stamped and punched and affirmed. But only summons, Lordship will give me short service. I'll lodge it.
Why waiting for so long?
Same situation. Interim order 31st October. 29th October, order was for same matter, that very matter. There are multiple defendants. Lordship allowed one of them, 5 to 20. I am for 5 to 15. I am for 16 to 18.
And I am for 21 to 25, my lord. It's
On what ground I allow?
But your Lordship allowed that because of these reasons, the written statement could not be filed within 30 days and papers were voluminous. And also
that 11 says.
Yes, that matter.
Mr. Devnath Ghosh.
He argued for plaintiff and Mr. Rupak Ghosh argued for the for those defendants. I am for some other defendants having similar claims for other set of the written statement. And my friend is also for some other defendants.
Written statement is also a stamp.
ঠিক আছে নাও কস্টগুলো এই লাস্টের দিকে যারা ওয়েট করে আসছে না কস্টগুলোকে হেভি করে দেবো শেষ অবধি ওয়েট করে আসছে কস্টগুলোকে 3 গুণ করে দেবো ইয়েস লাস্ট ডেটে একদম মেক ইট আ প্র্যাকটিস করে দেবো
Guideline, Lordship has given a guideline.
Yes, that does not mean indulgence.
No, absolutely.
Every matter, if comes 116th day, 119th day.
This is a bit earlier.
Very well.
Not at the fag end.
Very well, very well. Let me see. No, I will also fix the slab of cost.
Yes.
Lordship had done 50,000 in.
That whatever is
that
done,
was
done.
20th day. So we will be less than that. We'll get from that.
Let me test as a test case. I will put it higher than that. Key. Short service of notice of motion.
Maybe disable this tomorrow or day after any day, Lordship convenient.
You come with them. First you get the number, file it, then.
My lord, the date has to be given.
No.
Returnable date or master.
Sorry, short service of notice of motion, I said. File with the short service.
But
Then get the number and come back, then I will give you date when it will appear.
My lord, master will write in the master summons that this will be the returnable date.
No, but if the short service is...
Which means next day. So returnable will be tomorrow. Kindly, Miller,
72 hours.
if Lordship gives me leave to tomorrow.
আচ্ছা এক কাজ করো ওই শর্ট সার্ভিস করে টুমরো করে দাও এটা আর ঠিক আছে করে দাও
Two separate applications for different set of defendants.
হ্যাঁ ঠিক আছে আরামসে grateful
করে দাও কালকে রিটার্নেবল করো বাট গিভ নোটিস এন্ড অ্যাফিডেভিট অফ সার্ভিস Next.
But I appear for the plaintiff. There is an
defendants.
All sole plaintiff, sole defendant.
Sole defendant.
There was order by.
Take the microphone.
There was an order passed by this honorable court, my lord, on 25th of September, giving me the last opportunity to file an opposition to an application they had filed for judgment.
I can't hear you. Take the microphone. Yes.
But I am appearing for the defendant, my lord. By an order dated 25th of September, this honorable court had granted me a last opportunity to file my opposition to an application for judgment upon admission, my lord. I am, my lord, out of time, my lord. I was
again you are out of time.
I am again out of time, my lord. I am beseeching your lordships to, my lord, kindly grant me time till Friday, my lord, to file my opposition, and my lord, in the meantime, I have complied with the provisions of the Commercial Courts Act. I have complied with the provisions of the Commercial Courts Act.
What are the provisions?
My lord, the statement of truth has to be filed, my lord.
That's the written statement. That is the written statement.
My lord, this is a transferred suit, my lord.
So
The written statement was filed, my lord, prior to the transfer.
right, so it has to be cured.
Yes,
Yeah.
but the statement of truth, my lord, the list of documents, my lord, under Order 11 and Order 11 Rule 1 and 2, and list of documents under Order 11 Rule 6, my lord. Those, my lord, the liberty was already granted by this honorable court. My lord, may I have your lordship's leave to file them?
Ashwin?
Not only kindly see Malad the last order. Malad their right has already gone to file the affidavit. Kindly see the order of 25th of September 2025. But kindly see paragraph 5. Time was given Malad to file it 1 week after the reopening. That ends on 31st of October. Kindly see paragraph 5. It is made clear that if the defendant fails to file affidavit in opposition and complete the compliance of provisions of Commercial Codes Act, the application filed by the plaintiff will be taken up for hearing without the affidavit.
Yes, my lord. But I was seeking a lordship for last opportunity, my lord, till Friday, my lord, if I can file it.
You missed the bus.
But I've already complied with the provisions, my lord.
Yes, but you have missed the bus. What to do?
But till Friday, if my learned friend doesn't oppose me.
The defendant has not filed. Mr.
Orithra Basu.
Orithra Basu, learned advocate, appears for the plaintiff. Mr.
Uttiyo Malik, my lord. Uttiyo Malik. U-double-T.
Malik,
Yes, my lord.
learned advocate, appears for the defendant. The last paragraph, the last paragraph, the last order dated September 25, 2025 shows that the defendant has not filed affidavit in opposition as per the direction passed by the court earlier, and also not complied with the provisions of the Commercial Court Act. But still, an opportunity was granted, last opportunity was granted to the defendant by extending the time period till 1 week after Puja vacation. Postal. The 5th paragraph of the order further records that if the defendant fails to comply with the direction within the said extended period, the application filed by the plaintiff will be taken up for hearing without affidavit. Paragraph. Today, when the matter has been taken up, Mr.
Uttiyo Malik, my lord.
Learned advocate appearing for the defendant further prays for an extension. Post. Paragraph. Though the last direction was peremptory, but for the ends of justice, upon imposing certain condition, a last chance is given to the defendant. Paragraph. Subject to payment of cost of rupees 30,000 to be paid by the defendant in favor of the State Legal Aid Services Authority, West Bengal, within 7 days from date. The direction extended on September 25, 2025 stands further extended till আজ কত 10 আজ 17 মধ্যেও কজ দেবে November 24, 2025. Full stop. Paragraph. The defendant shall produce the money receipt, copy of the money receipt before the learned advocate on record for the plaintiff, and shall produce a copy on the next day before the court when the matter shall be taken up for consideration. Paragraph, the matter shall appear under the heading adjourn motion on কবে দিয়েছি ওকে টাইম 17 অবধি দিলাম না না ওকে 24 November 26 2020.
May I make one small? My lord, I have partially complied with the order, my lord. I have
Whatever you have complied, not complied, not.
In the meantime, my lord, let there be an
partially I have
interim order.
complied, my lord.
In the meantime, my lord, brother, this is judgment upon admission application. They have admitted their liability. My lord, in the meantime, let there be an interim order.
Next.
My lord, may I lordships leave, my lord, to file the compliance, my lord, under the commercial.
What compliance?
My lord, I have partly complied with the order.
So come up with the full compliance upon payment of cost.
But the cost may be reduced, my lord. I have already partly
no.
complied, my lord.
Next.
Grateful, lord.
My lord, I appear for the defendant, and there are, my lord, 4 applications. The coordinate bench, my lord, while having determination, was hearing the application filed by
You
us.
appear for the defendant.
I appear for the defendant. There is an application under sections 5 and 8. Because I am saying, my lord, there's an arbitration agreement and the disputes are covered by the arbitration agreement. So the entire dispute should be, my lord, carried in the reference. To which, my lord, the plaintiff has filed an opposition and there is a reply on board, and the learned judge was hearing this application. There are 3 other applications which are pending. One was, my lord, GA1 for injunction filed by the plaintiff. One was, my lord, GA3, which was for judgment upon admission, again filed by the plaintiff. And there is a subsequent application after the 5-8 application filed by my client, which is GA6 for addition of party. But I'm not.
একটা শোনো ওই arbitration act ঝেড়ে মুছে রেখো বাবা ঝেড়ে মুছে রেখো. Yes.
And there's a subsequent application filed by my client, which is GA6, which is for addition of party. Now that addition of party application was made.
Even 8 has to be heard.
8 has to be heard first. Now,
today you have taken a resolution.
Is a resolution, yes. He was here. My other side was here.
I don't mind if he is here.
Now that he is not here, my lord, I can't proceed. Now that he is not here, possibly I can't proceed because of that. I should not. So any day, lordship keeps it, my lord. We
First
are
off of the day.
First off of the day. 16.
Item number 17.
চলো ডাকতে থাকো.
Item number 18. Item number 19. Item number 20.
19 by room. Item number 19. 19.
There are 2, 19 and 20.
Where is your other side?
This I do not hear me. I say yes. Yes, come.
Sorry. Lord, I am for the respondent. Lord, this is an application under Order 9, Rule 13 for setting.
All the parties are here.
Yes.
We are only 2 parties.
We are 2 parties. There are only 2
We are
parties.
only 2 parties.
2 defendants.
No, one defendant,
one plaintiff. Come on, proceed.
May I proceed, my lord?
Yes. Whose application?
This is my application, my lord.
Order 9 Rule 13, your.
Yes.
You have suffered a decree.
Yes, party decree.
Decree
Yes.
suffered.
Yes. Kindly give me just one.
Opposition filed.
The proceedings are complete, my lord.
Yes.
I must indicate before your lordship at the very outset, my lord. Your lordship kindly comes to the order of the coordinate bench dated August 11, 2025. It is my duty to mention before, point out this, my lord, at the very outset.
Petition, opposition, reply.
There are 2 applications. One is Section 5. Another is main application.
Why 5?
Section 5 of the Limitation Act, my lord, for condonation of delay, my lord.
It's not filed within 30 days.
My lord, my lord, the section 5 application has been filed as an abundant caution because I'm telling your lordship, I have my lord asked for setting aside of a decree which my lord dates back to 1st July 2024. However, that particular decree, my lord, was modified by an order dated 6th December 2024. So if I consider that the first order merges in the second order.
First order.
So from first order, my lord, if I take my lord, then there is a delay.
Show me the
of
section 5.
But before that, my lord, may I point out the last order, my lord?
Dekhi last order.
Only one interview. There is no modification of this degree, my lord. Only the date is corrected.
Only the
Only date was corrected. Only that was corrected. Typographical mistake was made, and I prayed to the honorable court that this should be corrected. As
Where? Which date?
It was 21st. It was should be had been.
Take the microphone. Any one. There are 3 microphones.
It can be. It was only for 21st, but it was printed there as 24. That's
decree.
No date. A year of the decree.
So get that corrected first.
That was corrected. That was corrected. That was corrected by the honorable court.
Show me the correction order.
Yes.
It has to be corrected by the department also.
Yes,
in the decree.
By the department.
Page number 34 of the section.
Yes.
That is carried out.
Yes, carried out. Everything was carried out. All it was completely. They are simply coming to. They are coming here only to demolish the building which has been constructed already, without paying a single paisa.
Which order? Correction, show me.
So that page, my lord, 35 of the section 5 application, GA2, IAGA2.
GA?
IAGA2.
$129.
Yes. 129 days from the date of my lord decree. But so far as my knowledge is concerned, my lord, as I have explained, my lord, it is filed as an abundant question. It was an ex parte decree. I had come to learn about the decree from a separate proceeding. And I have explained in my petition that the knowledge of the decree.
Affidavit exchanged in section 5 in this extra delay?
In both the applications. This were, my lord, in fact, taken up together, my lord, because the merits are interlinked and the time frame is also interlinked.
Show me which order you are showing that correction has been made. Dated
6th of December. At page 34. The original order by which the decree was passed, my lord, that is at page 26. And the next order of modification or correction is at page, my lord, 34.
Page?
The first decree and order is page 26 of the IA2.
August.
Yes, my lord.
27th August.
Yes.
Lord, this may kindly be seen. The order copy. The order copy.
Then correction.
Everything is there.
That is, my lord, page 34.
August 25, 2025 may kindly be seen. My lord, this order may kindly be seen by the which was passed by the Honorable Justice Krishna.
Turn to come to page paragraph 5. Where? Page 28.
Yes, my lord.
This may I kindly be seen.
That is what I'm.
11th August of 2025.
Which order, which portion is corrected? Show me. Paragraph 5.
Degree 31st January 2020 instead of 31st January 2024.
Paragraph 9, I got it.
It is on paragraph number 9.
Page 5, para 9. Para 9.
Para 9, last line.
Para 9, last line, 31st January should be read as below 31st January 2021. That was the correction.
That's right. Now, has the decree been corrected by the department?
Yes, my lord. Everything was corrected.
Show. Show that the decree has been corrected, correctly drawn up.
Yes.
This is the modification you are asking, telling about.
I am asking for a setting aside of that decree because it is an expression.
You are talking about the modification of this modification.
Yes, that is a correction.
All right.
Say modification.
All right. Dekhi. Show me that it is corrected by the department.
And 27th August, this is also. My lord, this one also may kindly be seen.
Correctioner order ta kothay? Correctioner order ta?
That is at page 34.
30?
34. Now, on the last occasion, an order was passed on 11th August 2025, by Justice Krishna Rao, After preliminary hearing, I was asked to take an instruction as to whether my client is ready and willing to deposit an amount of rupees 70 lakh to the registry so that the ex parte order dated such and such can be recalled and the defendant may be allowed.
First order was for the minimum principal amount of 1,16,45,000.
ধরুন দেখি ধরো
First order আছে এখানেই বলা হয়েছে।
এটা কি ডিপার্টমেন্টের কারেকশন?
হ্যাঁ,
সেইটা জানতে হবে তো যে ডিক্রিটা অরিজিনালি কারেক্টেড হয়েছে কিনা।
হয়েছে।
Prior to done and complete the degree, order was corrected. Prior to done and complete the degree, that correction was made.
So that when the decree has been drawn up, prior to drawn up, correction has been made.
Yes.
So in the drawn up decree, it must show the correction.
Yes,
So where is the drawn up decree?
that date is not here. Only the
There is
date
a
is
difference of
corrected.
more than.
That was no correction. Only correction was for the year 24 instead of 21.
difference.
Sir, when a correction is made in the decree, original side root provides
In the order itself.
in the judgment.
Yes,
So the decree must contain that correction.
that date is not necessary because that is pleading was there in the.
Show me the drawn up decree. Very well. Yes, proceed. Then what happened?
Milord, that order dated, Milord, your Lordship has seen the order dated August 11, 2025, Milord. So, Milord, I have taken an instruction. It's, Milord, not possible for the...
Which order? Show me.
11th August 2025.
That was the last order. Order at the last order. 25th August. 2025. 25. August. Order. 11th August. 25.
That is what I have.
Yes.
It's a page.
Milord, we are standing on that. Milord, my instruction is that, Milord, he is not in a position to deposit that 70 lakh rupees. So, therefore, Milord, kindly hear me out and, Milord, decide the application. Because your Lordship knows that I don't know what exact suit they have filed. If it is a suit under order 37, Milord, then whenever I will come with my application to defend the suit, Milord, leave to defend. At that point of time, Milord, if your Lordship wants, Milord, condition may be imposed for, Milord, securing any amount. Because it emanates from a dishonor of check.
How do you arrived at this figure of 70 lakhs, not 75, not 60?
Milord, it was, Milord, by his Lordship, Milord. It has fallen from his Lordship.
His Lordship.
After giving them 2-3 opportunities, it has been done, madam.
No, but you have to secure. Otherwise, why the court will entertain?
Suppose, Milord,
Unless your bona fide is there?
Milord, suppose, Milord, it is a, Milord, suit under order 37, Milord, emanates from a
No,
check.
no. It is always at the discretion of the court, even at order 9 rule 13 stage.
That is.
Yes.
That I, Milord.
So deposit then.
Milord, my instruction is clear, but I cannot.
Then what to do? Nothing to do.
Kindly, Milord, in that even, Milord, hear the application, Milord. If your Lordship don't find any merit in it, Milord, dismiss it, Milord.
But then if I find any merit even, then how will you secure? He has already received a decree.
That question of security, Milord, will come, Milord, if I don't have any defense in the suit. But there was an arbitration clause.
Why?
An arbitration clause. The suit is the prima facie not maintainable, Milord. The suit is prima facie not maintainable. There was an arbitration clause which they have suppressed before the court. They have got, Milord, by several suppression, they have got the decree. I will show, Milord. They have given my earlier, Milord, address in the plaint when they knew that what is my new address. I will demonstrate how they knew.
It was not known to us. Nothing was.
It was incumbent upon them to mention my last known address.
You are a company.
No, I am an individual, Milord. I am an individual, Milord. I was carrying on a sole proprietorship business, Milord.
Milord, they were staying in there, have building in
You have
Alipur.
to secure.
Milord, today, Milord, I don't have any, Milord, ability to secure the amount, Milord. But, Milord, I have a very good defense in the suit. If I can satisfy your Lordship on that, if the suit is per se not maintainable, then, Milord, perhaps this stage of security, my lord, will find at the time when I will come up with my defense.
What will be your bona fide? Even if on merit he wins the suit?
If the suit is, I am on a point, my lord, before going into merit, my lord, the point of maintainability has to be seen. If the suit is not maintainable, I can show from this thing.
Show me the plaint.
Lord, plaint I have never been served. Lord, what happened? That is why.
Have you annexed the plaint?
Yes, we have.
Next question. Opposition point. No, my lord, that has not been in the record.
It was not. It was.
Your lordship
was not
to see the plaint also, because I have never seen the plaint. As of now. As of now, I have never seen the plaint.
Well, they have received. Yes, we have given that.
The date they have mentioned in the agreement, the agreement on the basis of which they are asking for the decree today, there was no such agreement on that date. They are saying 7th March. I have a agreement of 7th February, which was preceded by another agreement of 24th March. So all these things are on merit, my lord. That is different. But as on date, my lord, they have obtained a decree by suppression.
What is your ground under Ordinary Rule 13? How was you sufficiently prevented not to come to court?
Lord, the suit was filed on 29th of November 2023. In the month of June 2023, my lord, the property which they have, the address which they have mentioned in the cost title as my address, that property was, my lord, taken by the bank under the SARFAESI Act. Now, in the decree itself, in the order itself, your lordship will find that they were in possession of the second floor of the same property. So they know the entire property was, my lord, ultimately came under the bank's possession from June 2020.
What is the suit for?
Suit for money, my lord. So, I had a, they are claiming that there was a loan which I have defaulted. My version is that they have financed in my project. The project ultimately gone haywire, my lord, ultimately could not be repaid. But there was agreement for sale for other properties which they have not enforced specifically. And there was arbitration agreement which they have suppressed from the court. So ultimately, on that, my lord, I have, at the time of taking the amount, there was.
You have annexed your agreement with the petitioner?
Lord, that I have with me, my lord, I can file a supplementary affidavit.
No, you have not annexed in your application.
My lord, that is the defense, my lord. At the stage of Order 9, Rule 13, my lord, I have not talked anything about the merit. The merit, my lord, only I am confined my statements and pleadings to the extent that my address was not that which you have pleaded. You knew that the address was not that. Therefore, the summons could not be served. It is an admitted case. The summons could not be served. Ultimately, my lord, a substituted services were effected. And on the basis of paper publication, ultimately the order was passed.
So, where is the wrong? If on the basis of paper publication?
My lord, if today, my lord, they knew the address before the matter was posted for undefended suit. And even at the date when they have filed the suit.
Show me from your application that they knew the address.
But my specific pleading is at paragraph.
Pleading will not help. Show me the evidence.
I have to give the one by one, my lord, I am showing.
So you come on the next day.
First,
get ready and come back. Bring list of dates. Bring the entire.
Yes, I'll bring this list of it.
My lord, everything was known to me, and I have not done anything.
I am saying that everything was there in second floor, position of the second floor. They don't.
I have not position at all. No position at all.
The order records that.
Mr. Your name, full name, or not? Chakraborty, learned advocate. Appearing for the defendant submits that there are two applications. IAGA-COM
2 and IAGA-COM 3.
IAGA-COM
2 of 2000.
2 of 2024 is an application seeking condonation of delay in filing an application for setting aside of an ex parte decree. Next, IAGA
3 of 2020.
IAGA-COM 3 of 2024 is an application for setting aside of an ex parte decree. In a paragraph, paragraph. The decree is dated The ex parte decree is dated
27th.
August 27, 2024. Mr.
R.L. Joshi.
R.L. Joshi. Learned advocate with Mr.
K.C. Garg.
K.C. Garg, learned advocate, appear for the plaintiff decree holder. Affidavits are complete. Paragraph. Affidavits are complete in both these matters, both the applications. এটা কি একটা সিরিয়াল নাম্বারই আছে না 19-20 একসঙ্গে? তাহলে 19-20 একসঙ্গেই অর্ডার করো, মানে একটাই অর্ডার দুটো ম্যাটারে। Both the applications shall appear under the heading adjourn motion. On. January 12th. (2026).
But on that date, the plaint may be called for.
Paragraph. The original records in the suit shall be produced on the next day before this court. It shall include the records of the sheriff's office. তাহলে সার্ভিসটাও দেখা যাবে।
May I, my lord, come up with a supplementary affidavit also serving them?
What?
Bringing on record the agreements. Since the plaint will be here, my lord.
Then they will have to file an opposition there.
Give it within 7 days.
All right. On the prayer of.
No need. So in the suit, the agreement is filed.
Suit is there. In the suit, the agreement is there.
Yes.
Yes. ছেড়ে দাও, দরকার নেই।
But there are subsequent agreements also.
If you have not pleaded, not pleaded.
वो जे डेटটা দেখাবে সেই এগ্রিমেন্টে কোনো ডেট এগ্রিমেন্ট
इसके पहले तो वो है, बोल दूं एग्जीक्यूशन भी तो है।
Next. কি? আবার কি?
बोला कितना जनवरी?
12 जनवरी।
আজ কত তারিখ? Next.
Number 21.
I am appearing on behalf of the defendant number 2, your lordship. I am appearing on the defendant.
All me?
Yes.
How many defendants?
More defendants.
One proforma.
But only defendant number 2 is appearing in the suit application.
There are more than one defendant. There is more than one defendant.
Today there is a resolution. It's passed over.
Your lordship, only what I am seeking is, your lordship, may the GA4 in this suit also appear, because it was made returnable before the vacation in the order of 8th
What is
September.
GA4?
GA4 is my application to strike me out from the array of parties, your lordship. Because there is no claim, there can be no claim against me. I am not there in the transaction. There is no previous.
You are for the plaintiff.
We are for the plaintiff.
There is
But we are seeking to seek an extension to file an affidavit to that GA4 that my learned friend is mentioning. Kindly give us 1 week. It is getting affirmed today. Kindly give us 1 week.
You are for the plaintiff.
Yes, my lord. I am leading Mr. Dutt. Kindly give us 1 week to file the affidavit in opposition and make it returnable any day after that.
I do not stand in the way.
Has it been extended previously?
No, my lord. No, my lord. I don't think so, my lord.
Dekhi.
Or maybe once, my lord, subject to correction.
Not in the list.
No, GA4 is not in the
So how will
I
you?
know it's not in the list. Since Mr. Datto is mentioning, that's why I said if your lordship wants it, then my lord, I can only seek for an extension. But it can appear in the list any day along with these applications. Then your lordship, my lord, by that time, my affidavit would be ready. It is getting affirmed today.
You better do one thing. You get your affidavit affirmed and then serve it on the other side so that they can file their reply.
My lord, I shall do so. I shall do so.
In that event, your lordship kindly keeps item number 17, 18, 21 and the GA4, your lordship, on a same date because both the
Analogous.
matters are same item.
17, the 21 টা ডাকলে কি করে 17 18 না ডেকে
Pass over. It's been
Same
passed.
parties, your
Same
lordship.
parties, your lordship. They're
Same
passed over.
parties, your lordship. Two different suits.
এইভাবে অ্যাপ্লিকেশন গুলো নিব কি করে আমি তো জানি
Your lordship, this is a very short application. It can, it won't take more than 10-15 minutes.
No, then I have to take up all these applications one day.
Yes, your lordship,
The
kindly.
whole day may go.
Because your lordship, the only difficulty why I'm impressing upon your lordship so much because we are suffering an injunction order. Now your lordship,
You are asking that you are not a necessary party.
Yes, absolutely. What happened is that I can show from the GA1 there was no averment, no prayer against me. A supplementary affidavit filed. Their averment is made against me. Prayers added. And I am suffering an ad interim expert.
Without amending the plaint.
Yes, sir.
Plaint has necessary amendment.
I won't venture that far. I won't put my learned friend's case that high. All the basics are there in the plaint for getting an order against my learned friend. Lordship makes the application returnable any day. I shall satisfy your lordship. And I'll exchange the affidavits in the meantime.
19 একসঙ্গে করো
17, 18, 21 and the in this.
Oh, different suit.
There are two
Yes,
suits.
yes. Two suits.
No, তা ওইভাবে করবো না 21 দেখেছো তো 21 so let us concentrate on 21 সম্ভব না এইভাবে লিস্ট চালানো সম্ভব না let us concentrate on 21 yes 21 what is the application tell me
Their injunction application, your lordship.
place it
Very well, let them first place it, their injunction.
that's right whose application has to be he has to place but all the defendants are here today
No,
all the defendants are not here today.
তাহলে passed over for the day
My lord.
এইভাবে সম্ভব না ওই 17 সঙ্গে 26 তার সঙ্গে 38 not possible
Beseeching your lordship is that in both the suits, identical applications. One
Sir,
injunction application, they're
it's
identical.
not, I cannot take up like that I have to go every item if it is connected 17 18 I can take up together 2021 I can keep together but 20 39 41 52 sorry
Then your lordship,
All right,
at least
chalo, next.
GA4 be
next 22
GH3.
22
My
all the parties are here
yes.
how many defendants
There is an application for addition of party, but that is not appearing.
how
But
many
there are two
defendants
applications for.
no but that applicant must be here
No,
Mr. Bose was representing that application.
if an application is on the board
it is not on the board.
It's on board, not in the list.
It's J3.
what is this application for
This is an injunction application in my suit. It is a very innocuous application, my lord.
where is the applicant who have applied for addition of party
Well, I don't think those applications are listed today. Possibly the reason why he is not here. Mr. Moinak Bose was representing the applicants in those applications. But those are possibly not listed today, those applications. It's only Mr. Sen's injunction application which is listed.
There is suit for eviction on the ground of forfeiture. Breach of the lease. I have terminated the lease. They are continuing in possession. Obviously, when I file a suit for eviction, now injunction is only to that extent, but they should not, they are trying to make some construction. They should maintain the status as was prevailing. This is a very innocuous prayer, and that is the order which is
Mr. Dotto.
Which is the order which is continuing. I don't think if this order continues, my learned friend will suffer any prejudice. This is the first order which is continuing.
দেখি অর্ডারের শীটটা দিচ্ছেন না কেন?
Kindly take on November 4, 2024. That is the first order.
অর্ডারটা দিচ্ছ না কেন বাবা?
হ্যাঁ,
নেই তো, একটাই অর্ডার আছে এখানে।
4th of November.
এই অর্ডার গুলো কোথায় থাকে? মেন সুটের বান্ডিলে কেন যাবে যদি অ্যাপ্লিকেশন এখানে থাকে? তাহলে এই অ্যাপ্লিকেশন গুলো এলো কি করে? দেখি
That's what I'm saying. The suit should be expedited, my lord, because they are in possession. Just, my lord, the nature and character should not be changed. This much. In fact, they are in possession through further sublessees.
Yes, this injunction, if continues, where is the harm?
My lord, there is a provision in the lease itself which permits, my lord.
That has been terminated.
Please.
That termination is, my lord, not.
Take the microphone.
My lord, the termination is under challenge now because they have terminated the lease. Now they want eviction. I have filed my written statement in the suit. That will be tested whether the termination is right or wrong. Kindly takes one clause in the lease deed which is at page 59. Volume 1. Clause Roman 4. At the foot of that page. It is hereby mutually agreed by and between the lessors and the lessees as follows. Lessees shall be entitled from time to time to build, rebuild, and erect one or more buildings in the demised premises or any portion thereof, and make all additions, alterations, and renovations to the existing aforesaid building to be rebuilt from time to time, with or without demolition of the existing and or future building or buildings from time to time in accordance with law. And lessees shall have the right without consent. Lordship will come to 61. Typed copy is there. And the lessee shall have the right without consent.
Mr. Chatterjee, Mr. Dotto, so sorry. Mr. Dotto, good, bad, ugly, indifferent, the lease agreement stands terminated.
On the ground of forfeiture.
Whatever. The lease agreement is no more there. Right? So, how the court will enforce this clause? By vacating the interim order?
No, my lord, the termination will be tested in the my lord trial.
Precisely.
It has to be because
Correct.
they have said that the termination is
correct.
There is no provision of forfeiture in the lease deed.
Correct. That is the matter. It's a merit of suit. Correct. But in the meantime, if you come and say vacate this interim order, because there is a provision in the lease deed, let's say in your favor.
Yes. No, that is already effective.
But the lease deed has been good, bad, ugly, indifferent, terminated and is under the scrutiny.
Now, any order based on this, my lord, prima facie observation which lordship just now indicated would mean that prima facie lordship is holding that the termination is valid.
No.
Otherwise, my lord, clause 4.
The plaintiff in the suit, show me.
Plaintiff. Yes.
But only one clarification, if I may just give. Since this clause has been shown, this clause has been acted upon, building has come up, It has already been sublet. They are enjoying the sublease rentals from their subleases. So this, it is not that in terms of this clause they can get further right.
So then where is the use in having this injunction?
No, this injunction, my case in the plaint is this situation which is already there. I am not asking them to I am saying that is being altered again. Further construction.
Further construction.
Yes.
Kindly takes the
Listen
prayer
now.
which has been sought for, my lord. Kindly takes the, my lord, prayer.
I am only saying let the status quo be maintained. Whatever was the position, they have a 5-story,
Prayer?
6-story.
My lord, I want to show the averment in the petition and the prayer.
Show me the plaint.
Plaint. Plaint is not, my lord, the reliefs are there. Plaint is not annexed.
Show me the relief.
Yes. Kindly comes to page 15. The reliefs are quoted at page 15, my lord.
Page
15 of the application, volume 1. Part of paragraph 20, which starts at page 14.
Yes.
Kindly comes to page 15, decree for recovery of vacant and peaceful possession of the suit property being land so and so, decree for rupees so and so, decree for a sum of rupees 31,58,129 towards mean profit and so and so, inquiry into
Forget it. Let's concentrate up to prayer A.
Yes.
What is 15? Paragraph 15, the monetary decree?
That is the breach. Arrears
According
which they
to
had
them,
to pay.
according to them, there is
Acha,
an arrear. According to us, there is no arrear.
Basically,
eviction
the
and
entry
mean
order
profit
is modified to the extent that status quo shall be maintained as on the date of filing of the suit.
Absolutely.
That status quo has to be defined.
Status quo with regard to structure of the building.
Yes. Nature and character.
Structure and construction of the building. The nature and character of the building as on the date of filing of the suit.
My lord, kindly takes 2 averments from the application. Kindly comes to paragraph 23 at page 16.
Yes.
Plaintiff has recently on or about in the second week of September 24 noticed defendants have stacked huge quantity of building materials at the scheduled property, and upon enquiry has come to learn defendants intend to make further construction at the scheduled property.
So which means
as vague as it could be. As vague as it could be.
No. Fine. So I'm clarifying that as on the date of the filing of the suit.
Order on the basis of this averment in the application.
Huh?
My lord will be passing an order on the basis of this averment.
No. The order is already there. I am not passing any new order.
No, lordship is hearing it finally today. After affidavits. I want to show what is my stand to this, my lord, allegation in the petition.
Very well. Show.
One more paragraph. Para 24. Plaintiff upon enquiry has ascertained that the defendant has not obtained any permission from KMC enabling it to make any construction at the suit property. However, and despite the aforesaid, defendant is purporting to make certain construction work inside the building and are also in the process of making further construction at the suit property with a view to change the nature and character of the suit property, scheduled property. My lord, with these kind of, my lord, averments, the only document or one document which we usually rely upon, a plaintiff, my lord, who seeks an interim order, are photographs to evince that on this date, this is the, my lord, position of the property, these are the building materials that are stacked, and the defendant is trying to make construction. Nothing of the sort is disclosed. Now, my lord, kindly comes to the affidavit portion at page 22.
Yes.
I place 23 and 24. The averment in the application is upon enquiry. I have come to know from whom this was enquired, from whom he has come to know. We don't know. Kindly takes the jurat portion, paragraph 2. Statements made in paragraphs 1 to 27 are true to my knowledge. And on this basis, my lord, Mr. Sen's client gets an interim order. Now, my lord, kindly takes my affidavit in opposition.
Give me.
I know maybe. Page 22, paragraph. Page 22, my lord. Paragraph 37. Defendants, my lord, I am skipping the first 3 lines. Defendants have already replied to the alleged termination notice. It is incorrect to allege defendants are continuing with possession of the scheduled property illegally as alleged or at all. This is my specific denial. Because I say, my lord, I have sublet. It is denied that the defendants have stacked huge quantity of building materials at the scheduled property as alleged. Such allegations are imaginary and illusory. Inasmuch as defendants have not stacked any material at the scheduled property, question of the plaintiff noting such material allegedly stacked at the scheduled property did not or could not arise. Allegation is vague and same shall be demonstrated in course of hearing of the application. It is denied that any alleged inquiry was made by the plaintiff or that upon such alleged inquiry, plaintiff could have come to learn about the alleged intention of the defendants to make further construction at the scheduled property. Inasmuch as the defendants are not proceeding with any alleged construction at the suit property, question of defendants obtaining any permission from Kolkata Municipal Corporation or any authority enabling the defendant to make such construction at the suit property, or no construction or addition has been made by the defendant after the construction of the building, and there is no deviation existing in the building contrary to the building sanction plan. Hence, such wild allegation of construction did not or could not arise. My lord, if this statement, if this statement is being relied upon by the plaintiff, this means that my specific assertion in the form of a denial statement is that neither did you make an inquiry, neither did I stack any building material. The question of me approaching KMC to get any sanction plan did not arise. Further, my denial statement that I am not in possession, and previous to this, my lord, I have already taken the stand on record, even in the written statement, is this, that my possession has already, I have already, my lord, sublet, which was permissible under the, my lord, registered lease. I have sublet to others. So question of me further, my lord, raising construction does not. This is, my lord, I don't know why Mr. Sen's client wants this order, but on the basis of the, my lord, allegations in the petition and particularly this, my lord.
It was an ex parte order.
No,
so, my lord,
it has been continued subsequently.
But first order
but
is
ex parte order. Now, my lord, what material?
Affidavit of service. It is ex parte means they did not appear, but not that I chose to move it ex parte.
What material, my lord, if I may put this in the form of a question to myself, what material is available from the plaintiff side for the court to determine that the allegation of construction is true? My lord, there is nothing, my lord, disclosed. Even in the reply, my lord, while dealing with this bare denial, my lord, kindly, if lordship wants me to show your lordship the reply.
No, I take it. I take it. I take it from you.
But don't grant it, my lord. Lordship,
I take it from you. So these are all? Huh? Yes, Mr. Sen.
No, the lease has been terminated. They say that I have challenged the termination. Written statement is filed without any counterclaim. Even if it is assumed that there is any...
I will not look at the written statement.
Exactly. Now, so therefore the point is it or is it, I say this question to myself, not the duty of the court to preserve the status of the property, at least as on the date of termination, or because if the property is to come back to me, it must come back in the same situation as it was, as on the date of termination. I have said that I have made an inquiry and I have found out that there are building materials where there is a capable possibility of a construction being made at. He is saying that I have denied that. So if he has no intention to make any construction which is his affidavit case, then he should say that the status quo should prevail as on this date. As on that date, I am not asking.
May I make it easier for your lordship? Subject to my lord, Mr.
Always.
Sen. My lord, send someone to the property at the plaintiff's cost to see whether any construction is happening even today.
So what happens if it comes up tomorrow?
My lord, just to satisfy your lordship's conscience that yes, this allegation is
very
correct.
Easy way of saying.
No, it's not an easy way. Because lordship is, my lord, imposing an order of injunction, possibly thinking of imposing an order of injunction on my client. My lord, this exercise would make it very clear.
I say, my lord, this is an issue.
Apprehending that nothing would be found by the special officer.
Protection and preservation of the property.
Mr. Datta, if an injunction is restricted only as on the date of the filing of the suit, how will it affect you?
No, my lord. First of all, my lord, the application it can be as on the date when the, my lord, application was presented, not ante, my lord, the date
of as on the date of filing of the suit.
Yes. My lord, we really don't know what was the position. That is not
You were in the property affidavit.
No. The property was built in 1982.
Mr.
Thereafter, my
Dotto,
lord,
if the injunction is modified to that extent, that as on the date of filing of the suit, the status quo shall be preserved with regard to nature and character of the building. You are not affected. I will record your submission that you are not carrying out any further construction.
Because of the timing, the suit was instituted in 2024. The application was taken out much later after the institution.
Very well.
If it had
Let
been
me see
simultaneous,
when the application was affirmed.
yes,
But
Lordship,
he has affirmed an affidavit saying that I have not done anything since 1982.
So then where is the question of passing an order of injunction? If he is relying on that statement,
Today,
then
once
you
it is
can't ask
disposed
for,
of, it can be
then you
changed.
can't ask for an order of injunction.
Show me that statement.
That page, paragraph 37.
Which portion?
Page
Record that
22.
statement, my lord, and dispose of the injunction application.
Which portion?
Inasmuch as the defendants are not proceeding with any alleged construction.
One second.
It's at page, my lord, 22 of my opposition, part of para 37.
No construction.
Are I'm pachi now. 1 second.
Needs take around 15 lines from the bottom. Inasmuch as
the defendants are not proceeding
with any alleged construction of the suit property, question of defendants obtaining any permission from municipal corporation or any other authority enabling the defendants to make such construction at the suit property. No construction or addition has been made by the defendant after construction of the building in the year 82.
Very well.
And there is no deviation existing in the building contrary to the building sanction plan.
Therefore, why injunction, my lord?
Therefore, also no reason, if they have not done anything, then this status should be preserved.
When the complaint was filed?
My lord, application taken out in September 24?
No, February 25. Application.
Then the
it opposition.
My lord, application September 25. Sir, 24. I checked the my lord verification there.
No, it's my mistake.
Plaint file hoyeche kobe dekho to.
Yes. Plaint filed. Then presented on.
Plaint admitted on 10th July 24. এটা আমার এখানে লেখা আছে 10
Fair enough.
July, September.
Fair enough. So as on the date of the application.
Yes.
No,
this will be an order of court, of course.
Order of court.
Order of court. Lordship will. Well, because I say that, my lord,
I will record your submission because of the reason I tell you why. The reason being, good, bad, ugly, indifferent. If I take the plaint case, then the lease agreement stands terminated. Maybe bad. Ultimately, it may be held that it is bad. But the plaint case is terminated. The moment it is a plaint case that it is terminated, and he has presented an order of injunction on a particular day, as on that date, the status quo has to be maintained. As on that date.
Lordship has already, my lord,
indicated
Lordship's mind that this is the order, but I was feeling, my lord, that unless, my lord, the plaintiff who is pressing for an interim protection at the final stage is in a position to demonstrate with material evidence to justify this order, possibly he was not entitled to.
Averment in the plaint and the petition in this type of case is sufficient, according to me.
I stand in the opposition is very
clear.
Sir,
You
can record my submission.
I will record your submission. I will quote your statements from opposition.
But only keep the point open, my lord, for me to agitate that this finding today should not prevent me from urging.
Absolutely.
It is always there. An interlocutory finding will never bind.
Not only that, I will make that clear. The underlying right of the parties in the suit shall not be affected.
He doesn't want somebody to go and visit because
why should I?
He will not find somebody.
That's my discretion.
I just wanted to indicate.
Ashur.
May I take your lordship's kindly? I have to mention an urgent matter.
Single plaintiff, single defendant.
Yes. So they are the partners, yes.
They are
partners of one. One is the lessee. 2, 3, 4 is the partners.
You are appearing for?
My lord, defendants.
All.
Yes. Because one is firm and the others are partners.
Plaintiff is one.
Yes.
I am taking lordship.
Mr. Shakko Sen, learned senior advocate, appears for the plaintiff. Oblique petitioner. Oh, Mr. Rajarshi Dotto, learned counsel, appears for the defendants, oblique respondents. Paragraph. the plaintiff oblique petitioner is allegedly, listen to me, is allegedly the lessor of the suit premises, and the defendants oblique respondents are the lessees oblique partners of lessee. Paragraph. Reliefs claimed in the plaint is quoted below. Reliefs claimed in the plaint are quoted below. Quote 1. Didi. ठीक है? Full stop. Paragraph. The plaint was presented on or about
10th July.
Plaint was presented on or about
10th of July.
July 10, 2024. Paragraph.
And 19 June is filed. The plaint is filed on 19 June.
The plaint has filed. The plaint was filed on or about June 19, 2024. Paragraph. The instant injunction application was affirmed on or about September 3, 2024. First.
30th September, 30th, my lord. 30th September.
September 30, 2024. The principal plea, paragraph, pleaded by the plaintiff oblique petitioner in the injunction application, praying for interlocutory reliefs, are quoted below. Quote paragraph 23, 24. (22, 23, 24). (25). (23, 22 to 25). Page number 16. এটা হচ্ছে কোড 2. Paragraph. On the basis of the said averments, the petitioner prays for an order of injunction inter alia restraining the defendants from raising any construction at the suit premises and oblique or from changing the nature and character of it. Full stop. A further prayer has been also made restraining the defendant from alienating, encumbering, and oblique or creating any third-party interest in respect of the suit property. Full stop. Paragraph. Pursuant to the direction made by the coordinate bench. Parties have filed and exchanged their respective affidavits, right? Reply filed?
Yes, yes.
Poster. The defense, which is relevant, comma, as taken by the which is relevant, taken by the defendants, is quoted below from the affidavit in opposition. Paras 37, page 22. Quote koto didi? Paragraph.
Lord, could you also kindly record that we have the right to build constructions on the demise premises?
Huh?
We have the right under the lease agreement.
Coming, I will come. Please wait and watch. We will not. Upon the application being moved, paragraph, on the first day, on November 9, 2024, none appeared on behalf of the defendants. Poster. The coordinate bench passed an order restraining the defendants from raising any construction over the suit property or changing nature and character of the suit property, and also restrained the defendants from creating any third-party interest over the suit property for a limited period till November 29, 2024.
The date of the order is supposed to be, maybe I have it wrong, on 4th of November, not 9th of November.
হ্যাঁ কত বলেছি আমি না November 4, sorry, thank you. কি বলেছি? No, this interim order was extended.
Yes.
And still existing.
Yes.
The parties informed to this court today, that he said interim order was then extended from time to time and still is in existence. Mr. Shakkoshen.
The interim order extended last Friday only.
It's still in existence. Mr. Shakkoshen Lanet's paragraph, senior advocate, appearing for the petitioner, referring to the prayers from the plaintiff, submits that the specific case of the plaintiff is that the lease agreement stands terminated by the plaintiff. Full stop. Consequently, eviction has been sought for. Eviction of the defendants have been sought for. He submits that since the defendants have no valid right or interest on the suit premises, neither the defendant can stay there for a moment, nor can change the nature and character of the property or suit property, or can create any third party right or interest thereupon. Hence the injunction was passed, which is just and proper. This is your submission. Paragraph. What's your name?
Sarvesh Chaudhuri.
Huh?
Sarvesh Chaudhuri.
Mr. Sarvesh Chaudhuri, Learned Counsel, led by Mr. Rajarshi Dotto, Learned Counsel, appearing for the respondents at the threshold, refers to clause, এই দেখি কোত্থেকে দেখালো প্লেন্টিভ ক্লজ, লিজের ক্লজটা বাবা,
clause 4A, page
কোত্থেকে
59.
দেখালে আমাকে?
Page 59 of the
59,
application.
Page 59. Injunction application.
পিটিশন কি বললাম? Clause
4A.
Roman 4
Roman 4A.
refers to clause, Didi, clause থেকে bold, Roman 4 bracket a small English a of the lease agreement dated
17 June 1982.
June 17, 1982. Specifically at page 59 to the petition, and submits that under the said lease agreement, whereunder the respondents had been put in possession and granted a right and interest over the property, clearly permits the defendants that the defendants shall be entitled from time to time to build, rebuild and erect one or more buildings in the demised premises. In the demised premises. আস্তে আস্তে, হ্যাঁ, এবং আটকে কিছু অসুবিধা আমায় থামিয়ে দেবেন। Or any portion thereof, and make all additions, alterations and renovations to the existing aforesaid building to be rebuilt. Rebuild from time to time with or without demolition of the existing and or future building or buildings from time to time in accordance with law. Full stop. The lessees, being the defendants, have right without consent of the plaintiff to sublet or subdemise or create charge over and above the said suit premises. He submits paragraph. Learned Counsel Mr. Chaudhuri submits that these are the absolute rights created in favor of the defendants under the said agreement. And the defendants have exercised their rights under the agreement. Poster. Paragraph. Learned Counsel Mr. Sarvesh Chaudhuri then refers to the averments made in the plaint and the injunction application as referred to above, and submits that the allegations are bald and without particulars on which no order of injunction should have been passed. Full stop. More so, the order of injunction was passed against ex party against the defendants. These are your submissions. Next.
But my lord, also record that their allegations are not supported by any evidence like photographs.
The averments made in the plaint and petition are not supported by any material.
Replies, my lord.
Any further?
That's fine, my lord.
Perfect?
Yes, my lord.
Next. After considering the rival contentions of the parties and upon perusal of the materials on record, it appears to this court that admittedly the plaint has been filed with a relief that the lease agreement allegedly stands terminated, and as a consequence, the eviction of the defendants have been sought for. The challenge thrown by the defendants towards such contention in the suit as written statement has already been filed has to be tested in a properly constituted trial of the suit. Whether the termination is at all there or valid or lawful. Poster. This court, while adjudicating this interlocutory injunction application, shall not go for a mini trial on that. Shall not go for holding a mini trial on that. Poster. The court must restrict itself on the basis of the averments and the documents disclosed by the parties in the injunction application. The averments made by the defendants in paragraph 37 to the affidavit in opposition, comma, quoted above, comma, shows that the defendant specifically contended that it had been put into the possession of the property into possession of the property in 1982 in terms of the lease agreement. Full stop. Inasmuch as the defendants are not proceeding with any alleged construction at the suit property, comma, the question of the defendants obtaining any permission from Calcutta Municipal Corporation or any other authority enabling the defendants to make any construction at the suit property, comma, no construction or addition has been made by the defendant after the construction of the building in the year 1982. And there is no deviation in the existing building, contrary to any sanction plan. Poster. Poster. On consideration of the above, this court is of the firm and considered view that since an allegation has been, since the plaintiff has contended that the lease agreement stands allegedly terminated and the termination is under trial, and the said contention is under trial, and since the defendant has admitted since after 1982 they have not. That since after 1982, no construction has been met by the defendant. Even if an order of injunction is passed to a limited extent, the same shall not prejudice any right of the defendant, the rights of the defendant, the alleged right of the defendant, comma, if any. Paragraph. Considering the balance of convenience and or inconvenience and the prima facie case, this court modifies the order of injunction dated November 24. I'm so sorry. November 4, 2024. Aging. November 4, 2024, extended from time to time, to the extent that an order of status quo, parties, to the extent that the parties shall maintain an order of status quo with regard to nature and character of the suit premises, as on the date of filing of the instant injunction application, that is
30th September 2024. Na?
September
30th September.
September 30,
2024.
2024.
The application.
Application, yes.
Full stop. However, comma, the defendants and or their managing servants assigns shall also not create any third party right, title or interest in respect of the suit premises.
My lord, the reliefs have not contemplated restricting us from creating third-party interests in this application.
No, my prayer is there.
That has to be there. That has to be there.
They have
No,
already.
no. Lease says that you can demise.
Very
So,
well. Very well, my lord.
কি বললেন? Defendants and oblique or their main, comma, agents, comma, servants, comma, officers. Officers to hobe na? Assigns. Shall not create any third party right, title or interest in respect of the suit premises.
Would my lord also clarify that this shall not prejudice our right to sublet? Thank you.
No. You will not after that. Without leave of the court. Full stop. Paragraph. It is also made clear. It is also made clear that this court has not expressed any opinion on the merit of the claim and on the merit of the respective contentions of the parties in the suit, and this order shall have no effect or bearing on the underlying rights of the parties to the suit at the time of final disposal of the suit. Right?
Very well, my lord.
Paragraph. With the above observations and directions, this application being okay, come on, tell me.
But the suit can be expedited.
GA com number bold korben. GA com IA GA com number 03 of 2024 stands disposed of comma, without any order as to costs.
Today, now we have 3:30. Lordship will not look behind me.
Always afraid of.
Yes.
Are you not? Are you not?
আমাকে সেই ছেড়ে চলে গেছে একা।
You've done well.
3:30 হয়ে গেছে।
Extension of internet. Milad, item number 32 had mentioned in the morning, Milad.
Wait. 32 কি পরেরটা নাকি?
না।
So wait. Let me call the list. ও আজকে 3:30 আছে? Okay. 32
Milad. Extension of Milad interim order.
Come on, give me the order. Give me the last order. Tear it out and give it to me. Till today?
Till today.
আজকে কত? লিখুন। The interim order last extended on September 10, 2025 stands further extended till January 30. (2026) or until further order, whichever is earlier. The niche likhe dao, Mr. Nirmallo Dasgupta, learned counsel, along with MS Priyanka Dhar, learned advocate, appears for plaintiff Mr.
সৌরজিৎ দাশগুপ্ত
আসতে বলে কেন, জোরে বল।
সৌরজিৎ
দাশগুপ্ত learned advocate appears for
the defendant.
Sole defendant. Chalo, next. Any extension? Expiring?
That will continue in the list.
It will remain. Expiring tomorrow?
My lord,
Come tomorrow.
My lord, I am for the defendant in this matter. He came from Delhi.
Lord, last time when I appeared through the VC, my lord, I was told to come today. My lord, last time I called through the VC, my lord, I appeared through the VC. I am appearing
before whom?
Before
this. Last occasion.
Fix this matter today, my lord, at 12.
No, my lord. My lord, on last occasion, 29th October.
देखिए की मामला देखिए किसी जाइन देखिए order.
29th October 2025, this matter has been taken up by Justice Krishna Rao, and he has fixed this matter today at 12:30. My lord, this
for what reason?
For hearing of the matter. And
what hearing? Application or suit?
Application.
And this was the order.
This is the order, my lord. On 3rd of this.
Order is still tomorrow.
My lord, on 3rd November, this matter has appeared and I had made submission. My lord was directed me, if the matter will not be taken up, then kindly mention the matter at the time of rising.
So now you have missed the time.
This is the time, my lord. I am led by Mr. Shashank Devsudhi. He came from Delhi, my lord. But that's the reason we are mentioning this matter, my lord, because tomorrow it is not possible him to come.
All right. Yes, I will accommodate. Definitely.
My lord.
Ashut.
My lord, kindly fix the date.
Since the interim order is expiring tomorrow, that is November 11, 2025, and the matter is in the list today.
Item number 35 and 36.
Interim order is in 35.
And 36 is
35, 36.
36 is a vacation of the interim application.
Right, so 35 extend করে 38 এর লিস্টে রান করো, কি বললাম?
36.
The matter has been mentioned today by Mr.
SD Sudhi.
SD
Sudhi, SUDHI, my lord.
SUDHI. Sudhi, learned advocate.
For defendant.
Appearing with MS?
Preetu Chaudhary, my lord.
Preetu Chaudhary. CHOWDHURY. Learned advocate appearing for?
For the defendant, my lord, the same. Sole defendant.
Defendant.
By Mr. Shashank Devsudhi.
You have obtained the interim order. Paragraph Mr.
Brajesh Jha,
learned advocate, appears for the plaintiff. Paragraph, the interim order stands extended till January 30, 2020.
Only one indulgence.
My lord, we have filed a vacating application.
It's running in the list. It will be there in the
my lord,
list.
if my lord will extend till January 30th. My lord, it will be difficult for us. Kindly fix for a 10 days or extend for a 10 days. We want to make our submission because our bank account has been attached by
All right, but the applications are in the list. It will also appear tomorrow again. It shall be in the list.
My only submission, my lord, really, if my lordship accommodate me, my lord, since I'm coming, my lord. It fix it, my lord, on 28th, my lord, really, on any date, my lord.
Sir, fixing is not possible.
No, in the list 28th, my lord, I will come, my lord, really, I will wait for 28th.
Very well.
28th, my lord.
Full stop. The interim order stands extended January 30, 2025, 26, paragraph. On the prayer of
SD Sudhi, my lord.
learned advocate for the defendant, since the vacating application GA, COM
GA2.
IAGA bracket COM 2 of 2025 is there in the list.
As item number 36.
Both the applications shall appear in the list under the heading adjourn motion. In that application, affidavit exchange.
No, only my lord that I was praying 8th was the date to file.
They had not filed, my lord.
Our reply. Till 15th, we want that extension to file the
reply.
Well, opposition, because opposition to the vacating, my lord, application.
Then when they will file their reply?
I have filed.
We have already served upon.
How can you file? You have taken out
Interim
a vacating.
application, my lord.
You have taken out a vacating.
Yes, my lord.
He asking for filing an opposition to the vacating.
No, my lord. My lord, earlier direction we are given on the injunction application in which we have filed we are filing the opposition. We have already served upon them.
We are filing a reply to their first one and vacating application, my lord. Opposition has to.
You are filing opposition to injunction.
Application. Yes, my lord.
Huh.
They have not given their reply in spite of the direction.
It was the date, my lord.
So he will file reply is being for
Within this week only, my lord.
তাহলে এইভাবে করুন দাঁড়ান ফার্স্ট ওই ইনজাংশন অ্যাপ্লিকেশনটা বলো কি বললাম ভুলিয়ে এমন বাজে লিস্ট করা আছে কি বলো না ওই দুটো মামলা একসঙ্গে করুন কত নম্বর 35-36 দুটো একসঙ্গে করে অর্ডার করো কি বললে না হ্যাঁ on the prayer না শুরু থেকে আচ্ছা তাহলে এটা কি আইএ কত ইনজাংশন আইএ কম 1 অফ 2025 এটা কি ইন রে বলে করো দুটো ম্যাটার একসঙ্গে হবে তারপরেতে ইন রে আইএ কম 1 পড়ো না the matter has been mentioned কেটে দাও সব কাজ আইএ কম 1 এ করো since the interim order passed on when
It's passed on 6th, my lord.
9th October 2025, ma'am.
Since the interim order last extended on October 29, 2025 will expire tomorrow, that is November 11, 2025, Mr. Rajesh Jha, learned advocate appearing for the plaintiff/petitioner, has mentioned the matter for extension today, as it is in the list. Paragraph. The interim order stands extended till January 30, 2026, or until further order, whichever is earlier. Full stop. On the prayer of IAGA 1 cholche. On the prayer of MS Mr. SD Shudhi, learned advocate, appearing for the defendant respondents. Time to file affidavit in opposition stands extended till today. Full stop. The affidavit in opposition filed in court today is taken on record. Full stop. Copy has been served. Paragraph. On the prayer of the learned advocate for the plaintiff, time to file affidavit in opposition stands extended till Ajay Koto. Reply, affidavit in reply stands extended till. When you will be coming?
28th, my lord.
20th November.
Yes, my lord.
Ajay Koto? Till November 14, 2025. Full stop. Paragraph. এবার করো IAGA com
2 of 2025. I have
2 of 2025.
My lord, I have already served.
This is a vacating application filed by the defendant. On the paragraph, on the prayer of what you are submitting?
My lord, I have already served upon them my
The vacating application they have said, we will file opposition to that.
On the prayer of the learned advocate for the plaintiff, time to file affidavit in opposition stands extended till কবে বলেছি ওটা?
14, my lord. Earlier one 14.
till November 14, 2025. Paragraph. Affidavit in reply shall be filed on কবে বলেছি? তারপর
No.
ঠিক আছে, shall be filed on or before November 19,
Yes,
2025. Paragraph. Both the applications shall appear under the heading adjourn motion on November 20, 2025.
Grateful will.
My notice of motion with the for the vacating application. I have taken out notice of motion.
Notice of motion filed in court today is taken on record. Ashu.
Grateful, my lord.